Okay. This is the regular meeting of the Sunshine Ordinance Task Force, called to order on Wednesday, March 4th at 4:02 p.m. Mr. Young, would you call the roll, please?
On the call of the roll, Member Rumble. Present. Rumble present. Member Winston. Winston absent. Member Wolf. Wolf absent. Member Copra. Copra absent. I was informed by Member Copra that he would not be able to attend tonight. Member Pilpil. Pilpil present. Member Hepner.
Present.
Hepner present. Member David.
Present.
David present. Member Fisher. Fisher absent. Member Hinsey.
Present.
Hinsey present. Vice Chair Hyland. Hyland absent. Chair Washburn.
Present.
Washburn present. We have a quorum. In terms of agenda changes, I believe that we have a request for postponement regarding item number 8, file number 15008, complaint filed by Brian Brown against the San Francisco Public Utilities Commission. I do believe that a member from the SFPUC is present to answer any questions if you have them. And there is a memo regarding the complaint that was just distributed to all members regarding this file.
Okay.
Quick question.
Member Pilpil.
The request for continuance, how did we get that?
It arrived via email approximately on Monday of this week.
And we don't have that in our packet. In the future, when there are requests like that that come in enough in advance, could we just get copies of those as well? That would be helpful, just so we can see the context of the request.
I would like to note that Member Wolf is present.
Okay. I'll get a copy of this later, but I'm good. Do people want to see it?
We each got a copy.
Oh, that's a different item.
No, this is different. This was the request for
Oh,
continuance.
okay.
All right, so
And then we should hear from PUC.
first off, though, we typically, with the first request like this, we typically vote to continue the item. But since the respondent is here, we should hear from the respondent. But remember, David, do you...
I'm assuming that it was the filer who requested the postponement.
The postponement was requested by the complainant.
The complainant. Okay, thank you. That was the only part I wasn't clear about. Thanks.
But at this time, I'd like to hear from the respondent. The respondent has a representative here.
Good afternoon, Chair Washburn and committee members. Suzanne Gauthier, representing the San Francisco Public Utilities Commission, responding to file number 15008, a complaint by Brian Brown. In the complaint, he asserts that we were both late in responding and were incomplete in responding. The memo you've received this afternoon does indicate the time frame for our acknowledging of the response, as well as providing responsive documents. We feel as if we have satisfied the request by providing any and all responsive documents in the time frame allowed by the ordinance. While Mr. Brown did request that we respond on the 6th day of February, we did respond on the 9th. There was a bit of a confusion because he does have 2 email addresses. And on the 6th, we sent responsive documents to the email address not associated with the original request, but still associated with Mr. Brown. On the morning of the 9th, we corrected that error and sent responsive documents to both email addresses. As you are well aware, the request time frame is generally 10 days. The request came in on the 2nd and was fully responded to on the 9th. So we feel as if the complaint somewhat lacks merit and should be dismissed. We appreciate your time, and I'm happy to answer any questions.
I just have one question. Suzanne, it's good to see you.
Nice to see you, too.
She and I served on the board of the League of Women Voters together. So have you sent this document to Mr. Brown? No, it's dated today.
It's dated today. It was provided for you. It was because I felt as if when I had sent the packet of materials to you that included our correspondence with him, I failed to provide you with a cover letter. So this serves as a cover.
All right.
It was not provided to Mr. Brown.
So,
Excuse me, Member Pilpel?
so two things. So a copy should go to Mr. Brown. I neglected to mention that I serve on the PUC's Citizens Advisory Council Committee, but I don't think that'll bias my work on this matter. But actually, the question to Ms. Gauthier at this point is whether the PUC would oppose the continuance request. We're not yet to the merits. Your discussion was wonderful on the merits or whatever, but we need to hear as to what your view is on the continuance request.
I'm here in hopes that we avoid a continuance and can just expedite the matter. As to an objection formal, I would not be in a position to make that objection. If we're asked to continue, of course, we will come back.
Okay. So as I
Thank you.
mentioned earlier, it's our tradition, it's our practice to allow a continuance, particularly for the complainant who's brought the matter to us, and this is the first request. So I have a feeling we'll go that way again. So, but Mr. Brown will receive this document that you provided to us.
Absolutely. We can get it to him this afternoon at both email addresses.
Okay, thank you so much.
Chair Washburn?
Yes,
Yeah,
Member
through the chair.
David.
I was wondering if maybe we could ask Victor to speak with Mr. Brown and see if this document basically fulfills his request, and that if it's possible that Mr. Brown, obviously offer him a continuance, but perhaps this will fulfill what, the information that he was looking for. Is that possible that you can reach out to
I will
Mr. Brown?
inform him of the continuance if you do approve that motion, and I will ask him if this new document's, I will pose that question to him.
Perfect, great.
Right, so it is also our practice that our administrator very often works to mediate a matter before it reaches us. All right.
Mr. Young and I have experienced that together in the past. Much appreciate his efforts.
All right. At this time, is there a motion to continue this matter?
So move to continue the matter to the call of the chair.
Second.
All right. Is there any public comment on the motion? Okay. Seeing none, without objection? All right. Thank you so
Okay.
much.
Thank you for your time.
That motion is passed without objection. Member Winston was absent, and Member Copra was absent.
And it looks like everybody's here.
Next.
Everybody who was planning to be here is here.
Yes. I just wanted to note that one of the items on our complaint committee recommendations, item number 17, the respondent is present to speak to that item. However, they must leave by 7 p.m. today, if possible. Next on the agenda, item number 2, approval of minutes of the Sunshine Ordinance Task Force February 4th, 2015 meeting.
Do I have a motion to approve the minutes?
Also move, I have some edits. I don't know if you had as well.
I do as well.
Okay.
Do I have a second?
Second.
All right. Is there any public comment on the motion to approve the minutes
As amended.
as amended? I have some typos, and I particularly, though, had a question about a more substantive thing. On page 11 of the packet, item number 12 in the minutes, I was just confused by why somebody could jog my memory, why we voted to continue this matter to the call of the chair. Was it
The title is listed incorrectly on the agenda. I believe you listed 67.21 instead of 67.16. As we have listed it incorrectly on the agenda, we could not approve it at that time. It is relisted on today's agenda with the correct title.
Okay, thank you so much. All right. So without objection,
Public comment.
I asked for public comment. There wasn't any. Okay. Mr. Young, could you call the next item on the agenda?
That motion was passed without objection with Member Winston absent and Member Copra absent. Next on the agenda, item number 3, approval of the Complaint Committee minutes for April 12, 2011, May 10, 2011, June 14, 2011, July 12, 2011, November 10, 2015, January 20, 2015, February 17, 2015. The reason we are placing these minutes before the full task force for approval is the Complaint Committee members are veritable, and just to ensure that the proper members are able to review the minutes, we are scheduling these before the full task force for approval.
Do I hear a motion to approve the minutes?
I was going to ask if we could postpone this to later in the meeting so I can take a look at them, and I'd also note that November 10th, 2015 hasn't exactly happened yet, so if that was 2014, then we should probably continue and renotice that.
Oh.
Someone else has had November of 2015. I'd like to hear how it worked for them. But
All right.
so if we could just postpone that till later.
So let's,
We can delay this to later in the meeting if you would wish.
I actually haven't had a chance to read through these either. I just looked at this.
Would
and
you
it
like to
was-
continue these to the next meeting?
Yes.
That
'cause
works too.
This
Is
is, and
there-
I need your full attention, Member Pilpel, so, okay.
And you will have it.
All right, thank you.
Is there a motion to continue this matter to the call of the chair?
So moved.
Without objection?
Is there any public?
Oh, public comment, sorry. Say none, without objection.
Thank you.
Next on the agenda, item number 4, file number 14113, complaint filed by Sophia Deanda against Eugene Flattery and the Mayor's Office of Housing and Community Development for allegedly violating Administrative Code Section 67.21 and 67.25 for failure to respond to a request for public records in a timely and/or complete manner.
Okay, first the matter of jurisdiction. Do I hear a motion to find jurisdiction in this case?
So moved.
Second.
All right, is there any public comment on the motion to find jurisdiction? Okay, seeing none, without objection. All right, at this time, we'll have a hearing on the merits of the case, and the complainant first has 5 minutes to speak to this matter. Is the complainant, Ms. Deanda, here?
There is no response. I do not believe the complainant is present at this time.
All right. I understand the respondents are here. Okay. So, members, we have a situation where there is no complainant. This as happens from time to time, and this body tends to give more weight to the complainant as whether to go forward with the hearing. And have you heard anything from the complainant at all since you sent out the notices? Or
I have not received any response to my notice of hearing. However, this complainant does have a habit of not showing up at meetings.
Yep.
This is the second time this has happened with this complainant.
all right, okay, that's somewhat different. So rather than continuing this to, we could continue it.
I believe
to-
our policy should be, as with other items, would be to table the matter and allow the complainant to reopen it upon request.
All right, since she didn't explicitly ask for a continuance or.
Yes.
Okay. Member Pilpel?
I'm not opposed to that if that's the ultimate decision. I would prefer to defer this for a little bit and see if the complainant shows up within a reasonable period of time. Could be, we're a bit ahead of where one might anticipate. I think if we take the next case and come back and see where we are then. That's just my thought.
How does that sound?
Well, Chair Washburn, I'd be willing to do that for one case and one case only, because as was stated, this
Person.
complainant has kind of a habit of this. So I would actually even pick a time right now, because it's not fair to hold up the mayor's people.
Member Wolf.
I have a question for Victor through the chair. What was the final resolution of the previous situation where they didn't show up to a previous meeting? Did the complainant eventually show up to a later meeting, or has the complainant never showed up at a meeting?
This complainant has not shown up at a meeting anytime recently. I believe the last time this complainant was scheduled for a hearing, she requested that we set up special ADA accommodations with the
Listening device?
Not listening device, but she wanted a transcription of the captioning of the meeting, and we did set that up, but she did not appear at the meeting.
All right.
And this complainant has previously been before the task force about 5 years ago on other issues, so there's a longer history.
Okay. Previous history aside, it's 4:15. Some of you were late. So, I'm not calling you on it.
Pick a time,
So
and
let's
then we
pick
cut
a
'em
time.
off.
I like the idea of picking a time. So
Call 5 o'clock.
5 o'clock. Okay. So
Not here by
if she appears by 5 o'clock, then we'll have the hearing. If not, then we will table this matter. Yes?
Afternoon, Sophie Hayward from the Mayor's Office of Housing. I just want to clarify, so we're happy to have this heard at 5 or whatever time you say. Is it any time before 5? Should we stay until 5 or should we leave and come back?
I would stay. Okay, because she could walk in soon. Okay. If everything was going according to plan, it would be after 5 anyway, so.
I think in
All right.
practice, if we take the next item and see where we are,
Chair Washburn, you've got a question over here.
Yes, Member Wolf.
It seems like by that logic, the representatives from the mayor's office could come back at 5, because if we're hearing the next item, we're not going to finish before 5, so they could take the next 40 minutes and do whatever they need to in their office, right?
Yes.
build affordable housing for example.
Are you guys in
So-
this building?
No, they're at 1 South.
Okay. You can do whatever. Member Wolf
There's
is
a craft brewery around the corner.
Member Wolf is such a compassionate person.
We will delay action on item number 4 until 5 o'clock at a
Okay.
minimum. Item number 6, file number 14097, complaint filed by Michael Castanola against the San Francisco Fire Department for allegedly violating Administrative Code Section 67.21, 67.25, and 67.29-7 for failure to respond to a request for public records in a timely and complete manner.
All right. First, we have to determine whether we have jurisdiction. No one's contesting it. Do I hear a motion to find jurisdiction?
So moved. Second.
All right. Is there any public comment on jurisdiction? Seeing none, without objection.
Just a quick question.
Member Pilpel?
We were going to hear this, and the complainant wasn't here a couple of months back. At that time, we didn't get as far as jurisdiction. We just continued the whole thing. Is that correct?
I was trying to remember the same thing. I don't recall. But at any rate, here we are.
I think we didn't, so I think this makes sense. So I'm good. Okay.
Yeah,
Okay.
I've had this before.
All right, at this time, the complainant, Mr. Castanola, are you here?
Castagnola.
I'm sorry, Castanola.
The G is silent.
Okay. Is Mr. Castanola here?
Gnocchi.
Have we heard from him?
Yes, we have. I did receive email verification that he was aware and was going to attend today's meeting. I believe it's in the packet.
Well,
All right, so
5 o'clock.
yeah. Why don't we do it one more time, since Mr. Piccarello appears to be here, and I think someone from the fire department is here. Maybe if we do that one and then see what's happening. So fire's not going to be inconvenienced anyway. And if he's not here, then we'll table it. That's
Okay.
And point of
So
order,
in my
Chair.
left ear, in my right ear, I'd like to hear from Member Wolf.
I agree of setting a time, but because there was at least one hearing scheduled above him, he could conceivably show up thinking that he has a full hour to hour and a half. So I think 5:30 or 6 is a better time for, given where it is in the agenda.
All right, we're going to skip over this item. We've already found jurisdiction, and we will keep our eyes peeled for the complainant, and we will have the mayor's office matter, and then we will attempt to have the sheriff's office, police department, fire department, I'm sorry, fire department matter.
Chair, just point of order, not to be pedantic, but I think our fire department, I believe it's Captain Castagnola, I think is his official title.
Oh, okay.
So,
Captain Castagnola, okay.
We do not need to set a time at this time. We can just move on and come back to it.
All right, so, Mr. Young, would you call item number 7, please?
Item number 7, file number 15010, complaint filed by Thomas Piccarello against the San Francisco Fire Department for allegedly violating Administrative Code Section 67.21, 67.25, and 67.27 for failure to respond to immediate disclosure requests in a timely and/or complete manner.
All right, at this time, do I hear a motion to find jurisdiction?
So moved.
Do you hear a second?
Second.
All right. Is there any public comment on the motion to find jurisdiction? Seeing none, without objection. All right, at this time, Mr. Piccarello, you have 5 minutes.
this is a weird one.
Are the respondents here?
Yes, they are.
They are. Okay, thank you. I wasn't really prepared to go, but I'll go anyway. I think January, if you review your packet, and hopefully you reviewed your packet before you came here tonight, I sent an IDR to the fire department for records regarding 1121 Clement. I was a fire victim at that site. As I speak to you today, I've received a one-page incident report and nothing else. There is an arson report. I've received the arson report previously, but it was heavily redacted. So that's why I'm here today, to get an unredacted arson report and any and all other records regarding that fire that occurred in 2013. There is an issue with the fire department in that there is a subset in the fire department. Although Mr. Brown, I'm sorry if I'm mispronouncing his name, but one of the respondents here tonight, he holds himself out as the compliance fire records officer. Yet when an individual seeks records from the fire department, they have a separate subgroup called the Arson Task Force or some entity like that. And this, the individual who I can't pronounce his last name, it doesn't do any oversight regarding whether there's compliance by that arson unit of providing the documents that I requested. As to the other respondent, I can't pronounce his name. That's Captain Darman. I spoke to him on the telephone on the 23rd of January, and he assured me that I would get the arson report unredacted. He's sort of new with the arson task force. And he admitted that the fire department has a history of not providing fire records, and when they do, they're heavily redacted. So as we speak tonight, I don't have that report. That was never given to me. All I do have is a one-page incident report regarding my IDR that I sent to the fire department. If there are any questions, I'll sit down.
All right, thank you. Is there anyone here to offer facts and evidence in support of the complainant? Okay, seeing none, the respondent, you have 5 minutes to present your side of the issue.
Yeah, I'm Rob Bond. I'm the compliance officer. So I received the request from Mr. Piccirillo, and when we do receive a request for fire records, we usually will on our website. It does state that it does advise requesters to go directly to the Bureau of Fire Bureau of Fire Investigation to receive those records, which is the Arson Task Force. However, if someone actually requests from a public record, from the public record officer, compliance officer, and then we provide what we can, which is not everybody wants there's usually the fire incident report, and then could be the fire investigation report if the Arson Task Force actually went to that fire. And that's not always the case. So if somebody what I have to do is actually take a look at the incident and take a look and see what records that we have, and then if I would be able to provide the fire incident report. But if there is a fire investigation report that exists, then I refer the requester to the Arson Task Force to receive that record. And there's a reason for having that separate, because even though being a part of the fire department, it actually is more like a conglomeration of other agencies. And I think Captain Darmody can speak on that a little bit better as far as the differentiation between that.
Okay, thank you.
Good afternoon. I'd like to say, Mr. Pilpel, it's been a few years since I've been here on the other side of the fence. Yes. I don't know if you remember or not.
Absolutely.
Right, very good. But it's good to be here, hopefully, to clarify some issues for Mr. Piccirillo. I'm an advocate of transparency, and I've been on the other side trying to get information actually from the fire department and from the city as well. So no one knows better than I the frustration that you can feel, and I understand the process and the Sunshine Ordinance very well. And I just wanted to, I know I did not have to be here today, but because of my schedule and our needs in the city and the department, unfortunately, I haven't been able to be as timely as I'd like to be because of our priorities in the Arson Task Force. Short-staffed, a lot of fires, not excuses. Those are just facts I just wanted to throw out there. So my apologies for any delays in responding to the Sunshine Task Force complaint, but I thought if I came here tonight, I might be able to shed some light and maybe even try to reach out and see what portions of the redacted report I might be able to reconsider. To get to that, Mr. Piccirillo stated that he had received a copy of what we call the incident report. It's a statistical gathering process where 1 to 9 pages of pull-down menu statistics are printed up. It's almost like a form. And that report is typically given out to just about everybody who asks for it, with a few exceptions, in case there's a criminal case going on or there's a medical examiner's report that's pending. We don't have that in this case. That report was, I believe, issued to Mr. Piccirillo long before I became the captain of the Arson Task Force. I think maybe the beginning of last year, if I'm correct. After looking in the file and after speaking with Mr. Piccirillo, he's correct, we spoke. I think I contacted him via email on the 22nd. Didn't have his phone number. He sent back his phone number via email. I called and spoke to him, and we had a conversation. Just to clarify, my recollection of the conversation was that I confirmed that it was customary practice to redact reports. I did not want to imply that that was a negative thing. That's just a customary practice for a variety of reasons, including privacy and protection of witnesses and so forth and so on. I did not personally redact the copy that he received on February 12, 2014, but I do have a copy of that report that he did receive, and it seemed to be appropriately redacted. I brought tonight with me a copy of the unredacted report in an effort to find out if there's something specifically there that he could point out to me, and I can take a quick look at it, because I'm the only one who has the authority to make that call. And I'm more than happy to do that, to try to resolve any issues and information that, he may need. It doesn't mean I can give it to him, but I can at least maybe give him a better answer of why it was redacted. Because it's not a straightforward answer. There's so many different reasons that it could have been redacted. And since my predecessor is the one who redacted it, with my skills and what I know today, maybe I could find something in there that is actually releasable that was an error. I just don't know without knowing exactly what. That being said, I did bring a copy of the unredacted report that I'm more than willing to look at. I also have another copy of the redacted report if Mr. Piccarello does not, in an effort to just try to resolve this here and now. And one thing I looked at on the request didn't say anything about photos. I just took the liberty of actually copying all the photos, which I'm more than happy to give him tonight. That might even be of some use or use for him. It wasn't a written report or document. These are photos of the actual incident, and that might help Mr. Piccarello in his efforts to get information. So I actually brought a copy I can actually give to him tonight, and none of those photographs are redacted. That is really all I wanted to say, other than as a custodian of records, it is a level that is basically parallel with Mr. Rob Bond's work. Because I'm the arson task force captain, it's a task force with both the police and the district attorney's office. Cases may be criminal, there may be fatalities. We're investigating to see if there was any foul play. None of that existed in this case, but that is why we have a separate entity, the Arson Task Force Custodian of Records, to ensure that there's no compromise of any investigation, whether it be civil or criminal.
Okay. Thank you very much.
Sure.
Is there anyone here to offer facts and evidence in support of the respondent? Okay. At this time, we open the matter to members of the task force for questions for both parties. Members? Member Pilpel?
Okay, I've got a number of questions. Let me start with Mr. Piccarello. So your request, which is on several pages, but in relevant part, you were asking for, you made an immediate disclosure request to Fire Public Records on January 21st of this year for any and all documents, memorandum, emails, and all other communications regarding the fire that occurred on that specific date at that specific address. Right?
That's
what
correct.
We're looking for, everything related to that.
The email speaks for itself, yes.
Okay, so we're good. So let me get to them and ask them some questions. Thank you.
Oh,
So,
you finished with me?
I'm good for the moment. To Mr. Bond, you provided a number of documents here. The first thing that bothered me a bit on page 282 of the packet appears to be a confidential communication from your city attorney. I assume you're aware of that, and presumably you're waiving attorney-client privilege to provide, to make that communication public?
Yeah, I'm also aware that any advice that's given regarding response to sunshine request is not confidential.
Well, there was recently a court case that overturned that, but...
Okay, I didn't know that. Okay.
It's okay.
Look,
the privilege is yours to waive.
Right. If you're waiving the privilege, that's cool. I just want to be sure that your department head knows that you're doing that, and the city attorney, and that you're not just off on your own doing your thing.
Yeah, I was unaware of this new overturn of that law or whatever.
It's just a good idea to check with your city attorney on these sorts of things. So I don't want you to be out there. Yeah.
Thank you. Thank you for that.
As to the records that he was requesting, it appears that the record that you provided, where is it here, page 274, was this single report. So that appears to be at least a responsive record, and you're saying that that was the only responsive record that you had or that you were able to obtain outside of BFI? Is that correct?
Correct, yes, that I have access to, yeah.
Okay. Anything else would be within BFI, but in terms of a general incident report, that's what you were able to kick out, and you didn't get anything else from anybody in the rest of the fire orbit?
Yeah, the only other records that would be responsive to that would just be information that's already contained within that report. So it would just be like
an
a
export
duplicate.
of that, or, okay.
Yeah, so it'd just be redundant.
Okay. So moving from redundant to redacted, can you tell me on the second line towards the middle here why it appears the incident commander was redacted?
Yeah, because in that case, the incident commanders, it actually is not someone's name, it is their ID, and within their ID is their social security, the last for their social.
Okay. Could you have translated that to the name of the incident commander?
I believe you look down below.
Okay.
They're actually the.
Is it this Laura Kelly person?
Yes.
Okay. And is the okay. So on the bottom left, that's the same code?
Yeah, exactly.
Okay.
Yes. Yeah.
So just as a note to your IT gang, maybe they could fix that so it's reporting a name and not a code that includes somebody's social?
Yes, I have made that recommendation before in the past, and we have since made that correction.
Okay, so future reports will have actual names?
Yes, they are.
And if it were just the name, the name of an incident commander, the name of someone who reports to a scene of a thing, there's nothing protected about that, right? Is there somebody?
There is not, that's correct.
Somebody just doing their job?
Yes.
Okay.
Yeah.
Okay, so I'm good with that part of the thing.
Okay.
Let's turn for a moment to your concept that you do fire records except for BFI, and they're sort of their own place within the department. Maybe help me and the rest of the task force understand how and why that works, because my understanding is a department, you collect stuff from various divisions, provide it, rock and roll, and that we don't sort of send people to, I mean, if you're sending somebody to another department, I get that. If you were saying, for example, the incident report you're looking for, the police department has it because it's within the fire orbit, go see somebody at the police department records office, I would get that. But why you were sending somebody to somewhere else within the fire department, within your own department, when you're the public records guy for the fire department?
Yeah, because
Seems a little
the
odd.
Arson Task Force is more than just the fire department, it's also police and other entities too. And I think Captain Darmanin can speak on that better than me, since he actually works.
I'm going to get to him in a sec, but I'm just trying to understand as a basic thing how you're suggesting that any department can say, well, we're a department, but we've got this little unit over here, and if you want their stuff, you have to go to them.
I wouldn't like to have to do that.
Well, so
point of order. I feel like that he's now answered this question 3 times. That it's not just a part of the fire department. It's a unit that has multi departments reporting into it. The arson task force. So I'm like, I don't think you're going to get a different answer than that.
But I think the point I'm trying to make is that Mr. Piccarello wasn't asking for multi-departmental reports. He was asking for all records that the fire department had.
And it sounds like it was provided, and he was pointed to another place to get additional records.
But he was pointed to another place within that department.
Excuse me, Member Wolf?
I wasn't done, so.
Well, Member Pope, let me see if I can ask the same question in a different way.
Right.
Why is it not possible for you to contact is it BFI is the index for, why can't you contact them, get the document from them, and give it to the complainant or the respondent at that point in time? Mr. Piccarello happens to be more involved in understanding city business than some other people might be, and it could be quite confusing for someone to file a public records request for the fire department and not get an answer and have to go through there. So why isn't it possible for you to do the legwork there to get the document directly to the person?
There's a couple of reasons that for requesting fire reports, it's rather common. Not everybody is interested in the investigation report. Most people are interested in just the incident report. So therefore, it's actually in a way for me to send in to assume that they actually are requesting both is presumptuous, perhaps, of me. So that way, at least it gives them the option. That's one way that's one reason for that. And most people are satisfied with just that one document. Yeah, this is all I need. I don't need to go to this other, to go requesting the additional documentation, because this is sufficing for my purpose. And like I said, also, we on the website. It is stated there to receive the investigation report for all fire reports to go to BFI. That's what the directive is. However, if someone does come to the public records, that comes to me and requests the fire, in the investigation report, and then then I just refer them over to them. So the question is, why could I not? It's possible to be able to do that. Is it practical? It could be more timely to have to be the interluder going back and forth in between the two departments. We're not in the same location. We're in different buildings all the way across town. That's maybe another reason why that's difficult. And then there would be needing to basically invoke an extension because of having to records stored at a separate facility. So that would actually delay the process again. So that's actually in some ways it behooves the requester to actually go themselves to BFI to request rather than me having to go in between.
So you're saying that you can't send an email to BFI. BFI has electronic documents that they could send back to you. Like, is there actually does the physicality actually enter into this, or does electronic communication make that kind of moot?
Okay, I'd like to just keep us on track here. I don't want us to take the time to devise the best system here. I just want to know in this particular case, so Mr. Picarillo, it was immediate disclosure request that came to you for any and all documents. You sent him the incident report. And did you at that time tell him that if he went to the Department of Fire Investigation, he could get additional documents?
Yes.
All right, so you are required to help the requester find information. Mm-hmm. So, all right, and then Member David.
Yeah, I'm wondering if it's possible to kind of cut to the chase here. Mr. Picarello, could you step up? So, one very quick question. There is a timeliness component to your complaint, correct? That the IDR was not.
Yeah, I don't have any documents other than the one. So yeah, there's a timeliness.
There is. Okay,
I don't have any documents.
Fine, I got you. So my question is that it sounds like the captain has brought a lot of documents along with him tonight, and so my question to you is the following: is that if we were to rule on a timeliness issue, and would it be okay with you if you met with the captain to see if you could get the information you want? We would continue the rest of the case to the call of the chair, and that we can deal with the timeliness issue tonight. But it sounds like there's a possibility that the information you're looking for is actually in this room this evening.
Okay, I appreciate your question,
Yeah.
but if you listen closely to Captain Dorman, he said he would discuss redaction issues with me. So no, I'm not interested. I want the unredacted report. The fire department is not a law enforcement agency under your Sunshine Ordinance, and they have no ability to redact. Okay? But the fire department's position as of today is they do have the ability to redact. And the first report that I got on the arson report was heavily redacted with outrageous and ridiculous redactions. So, no, I don't want to sit with him. And let me just say this. He did not respond to the complaint, all right? He shows up tonight and gives you his story. You shouldn't have allowed him even to talk tonight because he didn't respond to my complaint. And I suggested that to Mr. Young. If you look in your packet, perhaps that email to Mr. Young is not in your packet, but I told him that I would object to Captain Dorman now talking or producing any documents tonight. When the complaint goes out to the respondents, they're told they got 5 days to respond, right? Captain Blariman, since I spoke to him almost 6 weeks ago, hasn't spoken to me. So I doubt his sincerity of me getting an unredacted report that I'm entitled to under the Sunshine Ordinance.
Okay, let's continue.
Can I follow up?
Member Pilpel.
Okay, thank you. And I think I'm done with Rob. I hear what you're saying. I'm sorry I'm not buying some of it. But anyway, let me go to Mr. Darmanin. Mr. Bond's memo to us on page 269 said that you would be providing us a separate response to the allegations. We didn't get anything in writing. Was there anything from you, or was it just your presentation earlier?
Actually, I don't believe I sent you anything directly. I sent an email to Rob Bond today. So my guess is you don't have it. My coming here tonight was to be present to, stand and answer to my failures, but one of them is not being able to provide a document. He received the document that he can get, and maybe another misconception is actually my unit is law enforcement.
Okay.
We're peace officers, and we do redact.
Okay.
Yeah.
I'm not to all of that yet. I'm
Sure.
still figuring out why Rob was suggesting that we would get some further response. The heavily redacted report that Mr. Piccarello referred to, I don't see that in our packet. That wasn't provided to us. So we're hearing about a report that we're not seeing. You're talking about photos that we haven't seen. Timeliness aside and procedural weirdness aside, it seems like there was a reasonable request for records like 6 weeks ago. You've got responsive records, however you want to characterize them, that haven't been provided to the complainant. Even if that gets handled some way now or in the future, I still think there's a violation, and it shouldn't take a complaint to bring the both of you to have a meeting of the minds and to discuss redaction in the hallway or before us. This just seems like this is not the way to do business. And I'm even okay with certain redactions that you might make. I'm not arguing about the specifics right now, but there may be circumstances where you might need to redact. But we don't have enough information before us because you didn't provide anything beyond. This just seems like a problem all the way around, and I'm struggling to find it. And Mr. Darmanin, you would appreciate more than most if it were on the other end. You wouldn't be happy with this circumstance. And
I agree.
However we deal with this instant case, I think you guys have to figure out a better way of dealing with this, because I can't imagine that this is the only request that you've gotten for a fire incident or an arson report ever or recently.
Sure. May I respond?
Please.
Sure. It might help to provide some clarification. There was some misinformation that was just stated by several people, and actually Mr. Piccarello correctly stated that he did receive a copy of the report. I don't know if everyone caught that. A redacted copy. So that's all I could give him today. He confirmed that he received that copy. So his request for something other than he already had could not be fulfilled. So his request was fulfilled by his own admission because he said he had a copy. Well, I'm here today to just provide maybe a second level, a second look.
Let me just be clear. Sorry,
Sure.
I'm going to interrupt for a second.
That's okay.
He asked for all documents related to that incident. If you provided him just a redacted incident report and you've got photos and you've got perhaps other things, it doesn't sound like those are documents provided, and that was, it seems to me, pretty clearly within the scope of his request.
He's received all the documents I can give him that in redacted form. The photos I did not believe was part of his request. I brought the photos just as a second thought when I was looking through the file in case he would want those. He probably doesn't want them because he didn't ask for them, but I brought them anyway because that's something actually I can provide. As far as any other documents in there, because we are law enforcement, any documents we receive from other law enforcement agencies, from other agencies, those documents have to be retrieved from that agency. I'm not at liberty to provide a police report when they have their own process for providing police reports, medical examiners' reports. So I'm not able to do that. But I think all he wanted was any and all documents that I can provide. And before I even was assigned to that office, I have a copy of his written request dated February 12, 2014, and it says it on the same day this request came in. So I'm not sure if he actually showed up in person or what, but on the same date it says it was delivered.
Okay.
And attached to it is the actual reports, incident and fire investigation report that was given that's redacted. And if I could add one last thing, coincidentally, we received a request from Supervisor Marr's office for the exact same report. I'm assuming it was probably in his district, and he wanted to know what was going on. We sent him an identical redacted report. The supervisors don't get any special treatment. They get exactly what everyone else gets.
I'm sorry, I'm not talking about Supervisor Marr, but I appreciate that.
Sure.
If you were making reference to a February 12th request, we don't have any of that information before us. All I'm looking at is a January 21st request for any and all documents, any and all, everything.
And if I was able to respond in a timely fashion, and that's my fault, and I accept responsibility for that, I did not. I would have put that in a response. And I apologize for that to everyone here, to Mr. Piccarello. But I'm here today voluntarily because I wanted to clear that part up, and that's why I still brought whatever I can now, and I'm willing to sit and talk with him to find out what exactly it is he needs, and I'm more than willing to look at it again and make a second effort to provide him with some of the redacted information if I can.
And can you just tell us then why that conversation between the two of you didn't happen before tonight's meeting? You had his number, you had his email.
Well, we actually spoke, and my effort was to provide him with a report. During that conversation, I didn't know that he had the redacted report. My staff person at the time, when I had a staff person, I no longer do, advised me that this particular letter and confirmation that it was delivered was in the file. So he had the report that he was going to get. So I'm unaware of any other conversations that happened between him and my staff.
Thank you. I'll leave it to others to figure out what to do with this, but I think that there are some issues here.
All right, and Member Wolf, and then Member David.
Sure.
I see that the request speaks to documents, and I don't know whether we have a definition of whether photos do constitute documents, but it seems to me that they should. And so it sounds like when this request was made, the effort to find these photos, whether they were wanted or not, was there a decision made that they don't qualify as documents?
We've never provided photos unless someone has asked. We've never looked at photos, digital photos, as a document, but not because we don't want to share. It's just that most people, if they want photos, they're going to ask. And that's usually an insurance company thing. But when I went through the folder, I said, oh, wow. He didn't ask for photos. Let me bring them tonight. So if he did want photos, I wish he would have asked specifically. I guess what we can do is, as a matter of being more transparent, ask whenever there's a request, would you like photos? We have them.
Great. Thank you.
So,
Member David.
I guess I have a question for DCA Cola around the redaction question. So Mr. Piccarella, I believe, made a claim that it is that the fire department is not allowed to redact, and so I was wondering if you could opine on that.
As far as the claims of the arson report redaction, there was no reference by either party to this complaint that there was ever a redacted version of an arson report submitted. This all came to light through the oral testimony that came out right now. So whether or not they were within their right to redact a report that I haven't seen, that wasn't included in this complaint material, I don't really know how to opine on that.
Okay, fair enough. And then with when documents are withheld, right, and when we know that a document is there, but that there is, but it's withheld, the Sunshine's ordinance says that you have to expressly say why you're withholding that information. Just in general, if something is being redacted, let's just assume that. That redaction's called for. Do you have to, under the Sunshine Ordinance, give the reason that it is being redacted? Does the same kind of rule follow?
I mean, anytime a responsive document is being withheld, you need to cite the specific authority under which it's being withheld.
Right, but in this case, right, this is somewhere in between. One's arguing that it's a responsive document that's not being withheld, it's just being redacted, perhaps heavily redacted. So then the question is that, does each individual redaction need to, this is attorney-client privilege, this is, the reason.
Yes, there's a provision in the ordinance to that end. You want me to find it? I'll find it.
No, if there is, then that's helpful to know. Yeah, okay.
Yeah, I mean, with redactions and withholding should be all kept to a minimal, and any time that an agency feels like that needs to be done, they need to provide an explanation as to why it was done.
Okay, perfect. So I'm assuming that on these redactions, there was not an explanation as to why, I'm sorry, Captain, that with these redactions, there was not an explanation as to why they...
I can't speak for the previous captain. This was 6 months before I got
there. Fair enough, but there's nothing in the records, no writing.
Not that I know of, no.
Fine, okay.
No. Although I think I might add that the redacted report, Mr. Piccarello could confirm or deny this, was provided over a year ago. And here we are over a year later, working on this. I don't know if he presented any complaint at that time to the captain at the time that he wanted an unredacted copy, or if he did, what was stated to him.
Yeah, and I think that's fair. And I feel like that there is some goodwill going on. You're trying to, make good on this. All that being said, there still is a responsibility upon the department that if information is withheld, that there needs to be a reason for that information being withheld. And so, yeah.
Can I just,
Member Pilpil, and make it quick.
I just want to clarify, because Mr. Darmany, you just made a statement that the previous captain in 6 months ago, this was...
I'm sorry, 6 months?
You just said that.
No, that's over a year ago.
Right. Yeah,
I've been there about 6 months.
Right, and you said there was a request a year ago and blah, blah, blah.
Sure.
All the information that we have is relative to a request from January of this year, 2 months ago, 6 or 7 weeks ago, not a year ago, not 6 months ago, very contemporaneous. So I'm getting confused when you're making reference to things from a year ago. That's not the request that we're talking about.
Well, no, and I understand that, but the report that he received previously was the only report he was going to get this time around, and he confirmed that he had a copy already of the redacted report. The actual redacted report that he got is actually in here.
In where? I'm sorry.
In our file at the office. I made a copy and brought it with me.
Okay, but it's not before us, and that's actually evidence that we would be interested in.
And I appreciate that, but I'm just saying there is a record of what report was given to him back in February. And what I was thumbing through here was there was actually, I saw an email from Mr. Piccarello where he discusses how all he had was a redacted report. So that's, I don't know if Mr. Bond has a copy of that email. I remember seeing it when I was rifling through these emails. So if I find it, perhaps it's in your packet as well. I don't know how big your packet is.
Okay, I want to hear from Member Wolf, and then I would like to hear the rebuttals.
Just a quick question for the captain. So if I'm understanding this right, a year ago he made some sort of request and got the redacted report, and then he made a new request on January 21st, and this time did not receive the redacted report because he had already received it previously?
That's what my staff has relayed to me, correct.
But it's my understanding that if someone requests a document, whether they've requested it previously or not, you're still obligated as an agency to provide it. Is there an exemption for
No, you're right.
So I'm asking why it wasn't included in this packet, why it wasn't sent again, why the photos weren't included. We've talked about how you weren't sure he wanted them, but it seems like we have an incomplete file here, and that is evidence of a failure to adequately respond to this sunshine request, because the previous sunshine request doesn't really doesn't come into play with the new sunshine request.
No, and I appreciate that too. And to be honest, I did not look at whatever complaint he filed. My assumption would be he would provide the redacted report that he got back in February. I was relieved to hear that he admitted he did get such a report, but he also did not provide that report for your review. I think that would have been important for him to provide as well.
But I'm sorry, that's not what I'm saying. I'm saying that we have the response from January when he filed a new request. We shouldn't really look at what happened previously. For all your department knows, there's two Thomas Piccarellos that happen to be roommates and share the same name. The second response that happened this year does not contain that report. Whether it's Thomas Piccarello's responsibility to have included it in our packet is beside the point, because he should have received it in this following this request on January 21st.
And I agree with that. Apparently it was not provided. I'm more than happy to provide it now, late. But I think the assumption made in the office was he already has the report. He said he had it, and that was the only reason why it wasn't provided again. In retrospect, I totally agree with you. We should just provide it again. If he asks 10 times, you can give it to him 10 times. And I have no problems with that.
Great, thanks. And then I also have one last question, which is that when he first got the report, I imagine it was an active investigation, and there's different rules about what needs to be redacted from an active investigation than from an investigation that's no longer under investigation, as I understand it. Is there still an active investigation regarding this incident?
Actually, when he first got the report, the investigation had been over for at least 2 or 3 months. So that investigation was completed rather quickly.
So what exists in this redacted version is stuff that needs to be redacted even though it's not an active investigation?
Correct.
Great. Thank you.
All right, at this time, the respondents have 3 minutes for a rebuttal, and then we'll end with the complainant's 3 minutes. So,
Rob, respondent's rebuttal.
What was the question?
you have 3 minutes for a rebuttal.
Oh.
To add anything extra to sum it up for us?
Actually, just looking here through the fire investigation report here, I'm looking at it right now with the redacted copy. I'm seeing there's name of the occupant, the date of birth, all the personal information about the occupants, the manager, the date of birth, cell phone numbers. Let's see what else is being. And then there's the names of witnesses to the fire. That's being redacted. That's what it looks like. A lot of this stuff that was redacted in here is basically is. It's not like a whole bunch. It's just basically that's what it looks like. All it is like the witnesses and personal information about individuals.
Thank you. Do you have anything else to say?
Actually, yes. When I came to the arson unit, clear instructions were given to me by my predecessor regarding redaction. This is after discussions with the city attorney's office, with the district attorney, with the police department. This is established practice and policy. I've made an effort to be responsive most of the time. It should be all the time. Unfortunately, I don't have all the time that I would like to spend on that. That's something that we have to continue to work on. So again, we dropped the ball to a certain extent. I dropped the ball, not Rob Bond. I did. This is my responsibility. But I could just do the best I can do, and I apologize for the confusion. The redaction is not unusual whatsoever. It's going to continue to be redacted. I'm offering to sit and talk, or he could send me an email if he doesn't want to sit and talk, and he could circle what he'd like to know, and I'll explain why he can't have it. Or I could just provide a complete explanation for every single redaction. I'm willing to do that if he doesn't want to chat about it, and that's fine. I'm just trying to be available and do my best at this point. Like I said, I have the photos. If he wants those, I'm more than happy to give it to him. That's all. Thank you.
Thank you. At this time, the complainant has 3 minutes. Mr. Piccirillo.
Yeah, first let me say that, it's hard for me to respond to him when we're speaking on this case. Again, he's had time to respond. He should have responded to the task force, and then I could have seen what his position was. But he shows up today and gives you a position creatively at best. Let me tell you, the Bureau of Fire Investigations, they're out in Hunters Point, and when I got the redacted report, I had to go out there. They didn't even have email at the time. So if I wanted the report, they would send it by snail mail, or I may have had to go out there. But I needed the report a year ago for another reason, so I had to go all the way out to Hunters Point and get the report, redacted as it was. And my request is not just for the arson report. My IDR speaks for itself. It's very all-inclusive. There are communications by Officer Kelly regarding the origin of the fire. The origin of the fire was by Internet Archive, a nonprofit in the city, but their insurance carrier is denying any and all liability based on that the fire was an act of arson. Officer Kelly spoke to that forensic expert. I'm entitled to those conversations. Captain Darman didn't include those, the discussion of those issues. So it's beyond the arson. I want an unredacted arson report, and I also want communications by Officer Kelly and her conversations with a forensic expert. That's the origins of the fire. Again, I was a fire victim. I lost everything in the fire. You shouldn't allow this captain to have the ability to tell me or anyone else who wants a fire record whether or not he's going to redact it or not. All right? So it's clear that the fire department is not responsive when someone asks for fire records. So, I'm willing to have him send me what he considers an appropriate arson report, but that's not what my IDR requested. I said any and all records. I want the conversations by Officer Kelly with the arson investigator opining that the fire was an act of arson. Captain Darman knows about that. And when I got the first redacted report, it was under investigation because Officer Kelly was talking to a forensic expert regarding the Internet Archive. Thank you.
Thank you. The matter is now with the task force. Member Hebner?
Sure. I've been sort of silently listening to what's going on, and my thoughts are as follows. I think that there have been lapses in the efforts to search for responsive documents. I'm not confident that efforts were made to look for communications, that efforts were made to look for responsive emails between members of the fire department that would be responsive to this request. Further, I think there's a timeliness issue. And one thing, just an admonishment to the fire department, and I'll keep it brief, but there seems to be a problem here where there's a shifting of the burden to Mr. Piccirillo, who requested these public documents. The fire department has indicated that it was Mr. Piccirillo's obligation to request why the redactions were made, that Mr. Piccirillo did not request photos at the time that it was produced. He said, well, Mr. Piccirillo didn't file a complaint about the redactions at the time that it was produced, as if that would obviate the fire department's obligation to indicate why the redactions were made. I think that's an inverted picture. That's an inverted view of what the fire department's obligation is here in responding to a public records request. So I would find violations on timeliness grounds and on completeness grounds. And recommend.
A second, I heard timeliness. I'm sorry. What was
completeness. This would be Yeah, 67.25, because that's what pertains to IDRs. 67.27, because I don't think that an adequate justification was made for withholding documents or redacting documents. Further, the section that requires complete responses, which is escaping me at the moment. I would urge this to be sent to compliance and amendments, but those are my thoughts.
So is that a motion? Oh, we need another. Okay, 67.21B.
Well,
Member Pilpel.
I was going to suggest 21C, because it's about identifying the existence and nature. 25A, about timeliness of the response, because it was an IDR. And 27, relative to withholding and justification.
All right.
Although I recognize, if Member David's about to raise a question, that the justification for the withholding is on records that we did not see. It was on the redacted report that BFI provided. So we're taking it on face value that, in fact, it was redacted, because we haven't seen it. So in case you were... Okay.
Okay, is there a second?
Am I making that, or you make? Who's?
I'm happy to make that motion.
Okay,
Yes.
so
I'm
Member
happy to
Hepner.
second.
Okay, Member
All right.
Pilpel. Member David?
Yeah, so I have no problem with these motions, with also finding the violations for what they said. It sounds like Mr. Piccarello has very specific documentation that he's looking for, and so that I would hope that along with our instructions, it sounds that there's
At the meeting.
correspondence with Officer Kelly that he's looking for. So I think that we can literally give a list of documents. It sounds like Mr. Piccarello has a list of documents in mind that he is looking for, that we could instruct the fire department to provide. And so I just hope that we will consider doing that along with our...
Right, we can be specific, and we should also say, and anything else we haven't listed, because he's asking for any and all.
Right.
Okay. I'm just trying to imagine if I were in Mr. Piccarello's shoes, I would want everything about my fire. Okay, at this point, is there any public comment on the motion?
I'm troubled by a few things in this complaint, just hearing it, not reading the documents. First off, the fact that there's no email correspondence between the complainant and the respondent is kind of troubling. And in this day and age, how do they communicate? Does Mr. Piccarello run out to some extreme location and hunt somebody down? It seems kind of incomprehensible. Was the IDR an email IDR? I think something's got to change there, because they need to open up communications. It seems kind of extreme to have to go to the lengths that Mr. Piccarello went through just to get information. The incident report is here and it's available, even though it's not in your packet. These people have it, so there's that. And there's one thing that, just from my own experience, is quite helpful as a complainant. If the respondent actually stands up and admits that they made a mistake and they're willing to extend themselves to meet with the person, I mean, it doesn't kind of erase the past and all the aggravation that was caused, but it's kind of a step in the right direction, and they've made it here. You don't really see that very often. Okay, bye.
Thank you. Is there additional public comment on the motion? Okay, seeing none, Mr. Young, or Mr. Member Rummold?
Could I ask that we separate the failure to provide a justification? For all we know, they did. Sorry. I was asking if we could separate the motions, the failure to provide a justification for redactions, from the other two, because we haven't seen what they provided or if they provided a justification with that. So if we could just vote on them separately, that's all.
Any problem with that, makers of the motion?
The request, and there's no.
Okay, all right.
That's an automatic request.
Okay, all right.
I'm sorry,
Member David?
can I just ask? So maybe I misheard, but I thought that I heard the captain specifically say that there was no justification provided, that was not in dispute. So did I hear that incorrectly? Captain,
I'm sorry, can you clarify what you?
So the question before us that we're about to vote, and one of the questions is that was justification provided for the redaction, right? So that you said, like, we redacted this, was written justification given as for the reason of the redaction, and I thought that
Written justification was not given, no.
That's what.
No, he just told me he had a redacted copy.
Perfect,
Yeah.
thank you. That was. I just want to make sure I heard that
Okay,
correctly.
Member Wolf?
There still is this weird procedural issue in that it's outside of the actual request, so I think it still does make
It's
sense
fine.
to keep it
Yeah, I
separate.
just want to make sure I heard things correctly. That's all.
Okay.
Yeah.
Member Pilpel, and then we'll vote on this.
Assuming this passes, we'll discuss this further at committee. I just observe that I know you guys, actually all three of you, are well-intended folks. In particular, the two fire people. It just appears that your story wasn't coordinated beforehand and we didn't have all the information. So in the future, if you're back here on something, I hope you'll have an opportunity to work together within the department. And I think one of the issues that Member Wolf just referenced is this thing of having, sort of a department within a department, which I'm still struggling with.
I was referencing something else.
Okay, all right. But anyway, that's still there too.
All right.
Thank you.
Mr. Young, would you call the roll on the
Yes.
motions?
Just to clarify the motions. On the motion to find violation of 67.21C for failure to identify the records withheld, and 67.25A, failure to provide the requested records in a timely manner. On that motion, Member Rummold.
Aye.
Rummold, aye. Member Wolf.
Aye.
Wolf, aye. Member Pilpel.
Aye.
Pilpel, aye. Member Hepner.
Aye.
Hepner, aye. Member David.
Aye.
David, aye. Member Fisher. Aye. Fisher, aye. Member Hensy.
Aye.
Hensy, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. Member Winston and Member Coper are absent. The motion passes. On the motion to find violation of Sunshine Ordinance Section 67.27 for failure to justify the withholding of specific documents. On that motion, Member Rummel.
No.
Rummel, no. Member Winston. Winston, absent. Member Wolf.
Pass.
Member Copra. Copra, absent. Member Pilpel.
Aye.
Pilpel, aye. Member Hepner.
Aye.
Hepner, aye. Member David.
Aye.
David, aye. Member Fisher.
Aye.
Fisher, aye. Member Hensy.
Aye.
Hensy, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. Member Wolf.
Aye.
Wolf, aye. That motion passes.
This should go to compliance and amendments.
Do you have any specific instructions to the department? List of documentation or
Well, first off, the emails that, or correspondence that were part of the investigation of possible arson definitely needed to be provided. Member Hepner, can you think of other things?
Yes, I want a review of the basis for the redactions in the report that was not included in our packet. But I want a review of that redaction in light of the fact that the investigation appears to no longer be ongoing, and a review of the request altogether. In the broadest sense, the request for communications, as Chair Washburn indicated, includes a request for all communications emails. These may not be contained in the folder that you've spoken of, but may exist digitally, in people's public email accounts, and those would fall under this request as well. Including all photos, which I believe are documents. So let's broaden the request and just review the steps that were taken to respond to this request in the first instance.
Okay.
May I add? I mean,
Member
specifically, I think Mr. Piccarello mentioned Officer Kelly. I don't want it to just be limited, but specifically Officer Kelly's communications and any additional communications that. And I also want to say that I appreciate the department's appearance of willingness to cooperate. That it does seem like that's my impression. So I hope that you will follow through on that.
And I
Okay, Member
also
Pabon.
add that when this item comes back to compliance, if the issue of this department within a department matter can be further discussed.
Doesn't seem to be our.
What?
I don't see how that is our role. I mean, we can discuss it, but I don't see how that falls under the Sunshine Ordinance Task Force.
I think it actually really does, because if departments start to say, well, you've asked for stuff from here, but there's stuff at 69 different satellite locations, you have to go to each of those places. I think that's what the department, in particular the department records coordinator, is supposed to do, is coordinate throughout the department. I mean, if we're suggesting that this department or any other department can set it up however they want, that's going to create a huge patchwork and all kinds of problems. I really see that as a big issue here in addition to the fire. I'm not minimizing the fire.
Okay, that seems like something for EOT, but don't lose sight of it. And Member Hepner.
Yeah.
If it's too big and you want to send it over to EOT at that point, that's cool too. But
I think it would be helpful, and I think I've already asked for it, but just a sort of a step-by-step, what efforts were made to search for documents and to respond to the request that was made. And that should include some explanation of Mr. Piccarello's issue regarding the department within a department.
I have the instructions.
All right.
Thank you.
An order of termination will be written and forwarded to all parties, and date of hearing shall be determined. I will notify all parties when that occurs.
Thank you.
Returning to item number 4, file number 14113, complaint filed by Sophia Dianda against the Mayor's Office of Housing and Community Development. Has the complainant for this item arrived? We do not have a complainant at this time. Fire Department, can you hold on 1 second? Okay.
Okay.
Thank you. Sorry.
This was the first request.
So this was not a request for continuance from the complainant. The
Right, that's
complainant
true.
simply didn't show up. And has a pattern of this, I suggest we table this. And the complainant can reopen it. Member Rommel?
Can I also add that I think if there was no, attempt to reschedule or postpone it, that we should table it and that it should be administratively closed at a certain point if the complainant has not asked to reopen it.
Okay.
So concluded?
Mr. Young, how
The
would...
motion is to table, and I believe our proposed rule change in the future shall be they have 60 days to request a reopening. If that doesn't occur, the matter is considered filed.
Okay, all right. So do I hear a motion to table?
So moved.
Second.
Is there any public comment? Seeing none, without objection.
The matter is tabled. I will inform the complainant of the fact and other steps that she may take.
Thank you, MOH.
Thank you.
Thank you so much.
Next on the agenda, item number 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction but not on today's agenda.
I was going to bring up my email to prove to you what I'm going to say to you right now. I'm bombarded with annoying emails from Kate Patterson of the San Francisco Arts Commission. Most are unsolicited from me, are repetitive, and in the past 48 hours, I received over 30 of the same email from Ms. Patterson, to the point where I turned off my phone, went to the city attorney's office this morning almost in tears to ask that they contact her to get her to stop. In typical fashion, I left a few phone messages at the Arts Commission asking for this to stop, actually to Tom DeCaney himself. And I filed a police report because I was getting them up until 3 hours ago after I sent her, putting her on notice that if I get one more email from her, I'm going to file a police report. And of course I did. I am asking the task force here to reprimand Ms. Patterson to get this to stop. This is a pattern of behavior that has gone on for 2 years, and it's driving me insane. I really don't even know why this is going on. I also get inter-office emails from various employees at the San Francisco Arts Commission. I don't want their inter-office emails. I don't know why they send them to me, and this creates further confusion. These people work in cubicles one next to each other and can communicate among themselves without involving me. This has been going on for quite some time. I've spoken about it at various full Arts Commission meetings, and it still continues. One of these inter-office emails I got was from Howard Lazar, noticing Rebecca Krill that he's entering another of my IDRs into the Sunshine logbook. It wasn't even an IDR that he entered into the logbook, and I wonder what is going on over there. As I've said before, I've spoken about this at many San Francisco Arts Commission meetings. I don't have the time really to review these abundance of emails I get from these people. And I ask for the millionth time, if an employee from the San Francisco Arts Commission has something to say to me, say it in one email. These are the 30 emails I got from Kate Patterson between yesterday and today. She's noticing me that I will be out of the office on family leave from August 29th to mid-February. During this time, I will not have access to email. Please read the information below for immediate assistance. This is mid-March. Why is this even going on? So I am begging you, please get this to stop. It's driving me insane. Here are the supporting documents. Thank you.
Thank you. Is there any additional public comment on matters not before the task force today? Okay. Seeing none, Mr. Young, would you call the next item on the agenda?
The fire department representative has not yet returned. So if I can move on to the next item temporarily. I would like to call item 9 through 13 together. They are related to the same item. File number 13085, complaint filed by Anonymous against Tim Fry, Historic Preservation Committee, Planning Department, for allegedly violating Administrative Code, Section 67.21B and 67.25A, for failure to respond to a request for public records in a timely and complete manner. Item number 10, file number 14037, complaint filed by Anonymous against Jonas Ionin, Planning Department, for allegedly violating Administrative Code, Section 67.25A, for failure to respond to a request for public records in a timely and complete manner. Item number 11, file number 14038, complaint filed by Anonymous against Lulu Hong, Planning Department, for allegedly violating Sunshine Ordinance Section 67.25A, for failure to respond to a request for public records in a timely and complete manner. File number 14039, complaint filed by Anonymous against Josephine Chung, Planning Department, for allegedly violating Administrative Code Section 67.25A, for failure to respond to a request for public records in a timely and complete manner. Item number 13, file number 14040, complaint filed by Anonymous against Rick Cooper, Planning Department, for allegedly violating Administrative Code Section 67.25A, for failure to respond to a request for public records in a timely and complete manner. I believe that all of these requests were regarding requests for information regarding the Park Merced project directed to individual members of the Planning Department. It was determined by the EOTC that these documents were provided to Anonymous via a previous request, file number 11068, and that EOTC determined that all the records were provided to her, and they concluded that matter. It was also determined that the department it was not a decision, it was an opinion, that the Planning Department can delegate the response to IDR requests to a custodian of records, and they do not each need to respond individually.
All right. Vice Chair Hyland, do you have anything to add about these items?
No,
No,
I think Victor summarized our EOTC findings on that.
So who appeared with these different cases?
Mr. Ionin was here, and we had the ADA set up for Anonymous, but she did not call in during that time.
All right.
And Ms. Lamarino was there as well.
Also correct.
All right. So at this time, members, do you have any questions, comments about these?
I believe the recommendation is from the EOTC to determine that the SOTF has jurisdiction over this matter and recommend that the SOTF conclude the matters as no violation of the Sunshine Ordinance has occurred.
All right. So we need to, first of all, agree that we do have jurisdiction, or no, has it already been found?
That
It has already been
determination of
found.
jurisdiction was made by the EOTC.
Okay. So at this time, do I hear a motion to, Member Pilpel?
No question. I was just going to say it's an omnibus motion that finds jurisdiction and finds no violation for all four. I think we can take it as one motion for the entire package. Yes?
Yes.
Okay. So,
All five.
yes, excuse me, 5. So I will so move that we accept the committee recommendation, which entails finding jurisdiction and finding no violation as to all 5 of these matters and concludes them.
And, okay, Member Hensy, okay. Seconded.
Is there any public comment regarding this matter? I do not see any public comment.
So, Mr. Young, would you call the roll on this motion?
On that motion, Member Rummold.
Aye.
Rummold, aye. Member Winston. Winston absent. Member Wolf.
Aye.
Wolf, aye. Member Copra. Copra absent. Member Pilpil.
Aye.
Pilpil, aye. Member Hepner.
Aye.
Hepner, aye. Member David.
Aye.
David, aye. Member Fisher. Aye. Fisher, aye. Member Hensy.
Aye.
Hensy, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. The motion passes. Returning to item number 6, file number 14097, complaint filed by Michael Castanola against the San Francisco Fire Department. Is the complainant present for this item? The complainant is not present.
So, did the complainant contact you, Mr. Young, regarding this?
I did receive an email from the complainant stating that they would be here at today's meeting. However, this is the second time that the complainant has failed to appear on this matter.
Nope.
All right. So, at this time, do I have a motion to table this
No,
or continue?
So at what point do we have as a task force, have we decided that we're, tabling and all that, like at some point it needs to be dismissed and the complainant needs to resubmit?
I think that's essentially what happens here. By tabling it, we're not voting on the merits. We're not reaching any of the merits. The complainant, if they contact Victor within a week, can reopen the thing and we'll see what to do. And absent that, it's concluded.
Through the chair, and that's one of the things that we're going to be discussing in a later item.
Okay.
And that we're formalizing that structure. We're just not quite there yet.
Okay, I just want to, I guess I just want to have some clarification that if we vote to table an item, that when Victor gives us our matrix at the end of each meeting, that, it shows how many opened
It will
items.
be listed as a non-open case, as it is not an open file.
Okay, that
It goes from pending to not so pending.
Right.
That was, thank you.
But we did, in fact, there was some communication from the complainant earlier. So it could be might show up in half an hour and we'll have to say, well,
We still have never seen the guy, if we ever do.
Yeah, we will you can reopen it, but not tonight.
Is there a second?
I'm sorry, what's the motion?
The motion is to table the matter.
Second, thank you.
Is there any, excuse me, yes,
Yes.
the respondent.
Yes. As a respondent, may I say something?
Yes.
Sure.
Okay. All right. So, just a couple of days after the last hearing when Mr. Castagnola failed to to show up for the hearing. I did send him an email, and I also CC'd the task force too. And I was asking, basically stating like, oh, I noticed that you weren't able to attend, that the task force will likely be giving you another opportunity. And then, nevertheless, I was reaching out to him at that time, to be able to say, like, is there anything else, that I can, do? Is there anything else I need? So it's one thing that I wasn't able to find out is that if he had opportunity to be able to search through records at his own fire station himself, at being a captain of that fire station. So that's when I never got a clear answer from him. So I did email him, and I never received anything back from him at all. No response, no communication at all from him. So that's all I wanted to say.
Okay, so this may very well go away. We don't know yet.
Yeah. So that's all I have to say is that, I did try to reach out to him to make communication, and I failed to receive anything in response.
Okay, thank you so much.
Right, sure.
All right. So, Member Rummel, were you going to say something?
Well, honestly, what happened last time when we continued it? Did he contact you, Victor, and
I contacted the complainant and inquired as to why he could not show up. He stated that he had an emergency, and I offered to reschedule it for this date, which I did do, and he did confirm he knew about today's date, but there is still no attendance.
Okay. I just don't want to get it in the world where he keeps rescheduling, and then not showing up. And I mean, it's already happened once. I'd be more inclined to just get rid of it, but now at least the onus is on him to come back and reschedule.
Exactly. Yeah, I think
Yes.
this is working well enough. Okay. All right. So, without objection,
No public comment?
no.
We asked
Is
for
there any public comment? No public comment. Without objection.
The matter is tabled. Moving on to recommendations from the Complaint Committee, item number 14, file number 14119, complaint filed by Ann Trabeau against the San Francisco Arts Commission for allegedly violating Administrative Code Section 67.16, failure to include written summaries of public comment in meeting minutes. This matter was continued from the last meeting of the Sunshine Ordinance Task Force due to an error in the title. The Complaint Committee does recommend that the SOTF has jurisdiction and recommends that the matter be concluded as no violation of the Sunshine Ordinance has occurred. I believe that the Arts Commission published their initial minutes without the 150-word summary. However,
Time's up, Victor.
it was corrected upon the return of the Commission Secretary prior to finalization.
Could we take 15 and 16 together, or do we want to do them separately?
Why don't we, is there anything you would like to add, Member Hebner? I'll let you fill in the details. He'll answer questions from the rest of the task force.
This is file number 14119. I don't believe this was heard by
By
me.
us?
Right,
Okay.
yeah.
Okay. Rules. Okay, rules, yeah.
Yes, I did confirm with Ms. Datesh that she would like to be known.
Oh, yeah.
Good change,
Sorry, let me pull this. That's page 503. Can you give me a second, please? What was your question?
I remember this.
Oh, yeah, thanks.
complaint.
Go ahead, Member Rummel.
Miss
Trabeau
had a disagreement about what should be included in the minutes. They were a draft version of the minutes. The statement was 250 words or 300 words or something like that. It was actually didn't need to be included fully, but it was a draft version of the minutes. They ended up including the full statement within the final version of the minutes, so that we found that there was no violation.
Okay. So is there a motion to accept the recommendation of the Complaint Committee for 14119?
Okay.
So moved.
Second.
All right.
Public comment?
Public comment? You're a party. You're not a member of the public.
She may comment.
Oh, you may comment now. I'm so sorry. Okay. Ms. Trabell.
Okay, this was just another example of the bad form and mishandling of things at the San Francisco Arts Commission. I appeared at a full commission meeting. I spoke under public comment. I waited the 10 business days for the minutes to post, and I saw that there was no public comment at all. So I sent an email to the commission secretary copying other people at the Arts Commission and did not receive a response. When I contacted Victor, sometime later, this public comment was revised and somehow showed up in the minutes. This was a mistake of Ann Trickey. It was a period of time that was about 20 days, and since I got no response from the Arts Commission, I filed a formal complaint. Who is Ann Trickey? She's the office manager. Why did she write minutes? We don't know. So I also want to go on public record by stating I was there in the Arts Commission offices last month. You ring a buzzer to get in. Howard Lazar refused to let me in. I had an envelope that I was going to drop off and get a receipt for, and there was a woman about 30 feet from the entrance of the door who was mouthing off to me, calling me a bunch of names, and so I said nothing. I left it there. She didn't want to write a receipt for the thing. Okay, fine. By the time I got down to the guard's desk downstairs in the lobby, this same person, Ann Trickey, and I have it on my cell phone, was screaming at the guard at the desk and actually accosted Pat Patterson of the Ethics Commission, who was coming into work that day. I again said nothing. The same Ann Trickey was screaming, "We have a restraining order to keep her out of the building," and the guard was saying, "Well, let's see it." And I said nothing. I went up to the management office, and over the course of 2 days, they were finally able to get her on the phone, and they warned her that she's disruptive to the operations of the building. And to stop this. If there is no restraining order, then why make the claims that there are? So, Ann Trickey, I don't know her in the same way I don't know Ms. Patterson, but I am guessing, and I went to the subsequent Full Arts Commission to tell them about this, that it's Howard Lazar who's the source of the problem. He just routinely mouths off to his co-workers and colleagues and makes up stories. There was no reason for that incident to happen. If they had responded to the email asking why wasn't my public comment included, I wouldn't have filed this complaint. It's just bad form, over and over again.
Thank you. Is there additional public comment on the motion? Seeing none, Mr. Young, would you call the roll on the matter?
On that motion, Member Rummold.
Aye.
Rummold, aye. Member Winston. Winston absent. Member Wolf.
Aye.
Wolf, aye. Member Copra. Copra absent. Member Pilpel.
Aye.
Pilpel, aye. Member Hepner.
Aye.
Hepner, aye. Member David.
Aye.
David, aye. Member Fisher.
Aye.
Fisher, aye. Member Hensy.
Aye.
Hensy, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. The motion passes. The recommendation of the committee is accepted. Item number 15, file number 14120, complaint filed by Anne Trabeau against Rebecca Krell and the San Francisco Arts Commission for allegedly violating Administrative Code Section 67.25 for failure to respond to immediate disclosures requests in a timely and complete manner. In summary, I believe that several requests were sent to individual members of the Arts Commission who were during the holiday season and they were not in the office. It was stated that out-of-office messages were set up. However, the complainant does not believe that she received those out-of-office messages. I believe that the Arts Commission has now set up a centralized email address for all incoming requests for public records, so that I have suggested that all public requests be copied to that email address, just so that if a person is out of the office, someone in the office will receive it.
Okay, thank you. This was before compliance and amendments, so Member Hebner, would you like to add anything?
I think Mr. Young adequately described the circumstances. It was fairly simple that the recipient of the request was out of the office. They received the email or the request the day that they got into the office and responded the next day. We were satisfied with the Arts Commission's representation that they had established a new centralized system for receiving requests and otherwise found the requests to be timely responded to.
All right. So any questions, comments from the rest of the task force?
One.
Member Pilpel?
To Ms. Patterson-Murphy, if you have a moment. Could you just tell us on the record this centralized email address for handling records requests? Could you just tell us what it is? I'm just kind of wondering. And I'm pleased that that's all happened, and welcome back.
Yes, it is. Hi, Kate Patterson Murphy, Director of Communications, San Francisco Arts Commission. Long time no see. Yes, that email address
still here, bud.
is on the website in the contact section.
Okay. Can you just tell us what it is?
It's like records requests at sfgov.org or SFAC records requests at sfgov.org.
And it's prominently on the website, so
Yes,
if you go to contact.
it's in the contact section.
Excellent. Thank you very much.
All right. Any other questions, comments? Is there a motion to accept the recommendation from the complaint committee?
So moved.
Is there a second?
Second.
All right. Public comment?
Okay, there are several issues here. Basically, on their website, it does say for sunshine requests, the email is sfac.recordrequests@sfgov.org. That is not being monitored because I sent several emails in this past month and got no response. The fact that Ms. Patterson can't even bring it up, the email is quite disturbing to me. I could show you my email. I have copied that email address and got no response. With regard to this complaint, the technique that they use very often is to claim that I got, for example, an out-of-office email, and what they use as evidence is them sending an email to another employee of the Arts Commission. That's not evidence. I didn't get it. It's a shame that there were several IDRs put in one complaint. I believe there was a violation, and the fact that this mix-up is still going on by virtue of the fact that I got 30-plus emails from Ms. Patterson, which were out-of-office emails between yesterday and today, speaks to the fact that it's still a mess over there. It's really sad. I think we've all been proactive. We've all made great, been very patient and made, trying very hard to make progress, and it's just not being made. I just want to go on the public record by stating that email, sfac.recordsrequest@sfgov.org, is not being monitored. And, here we are again in this weird twilight zone where Ms. Patterson lies and I present evidence.
Is there any additional public comment? Seeing none, Mr. Young, would you call the roll on the matter, please?
On that motion, Member Romold.
Aye.
Romold, aye. Member Winston. Winston absent. Member Wolf.
Aye.
Wolf, aye. Member Copra. Copra absent. Member Pilpil.
Aye.
Pilpil, aye. Member Hepner.
Aye.
Hepner, aye. Member David.
Aye.
David, aye. Member Fisher. Aye. Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland. Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. The motion to accept the committee's recommendation passes. Item number 16, file number 15001, complaint filed by Ann Trabeau against Sharon Page Ritchie and Rebecca Crow of the San Francisco Arts Commission for allegedly violating Administrative Code Section 67.7, 67.14, 67.16, and 67.25 for failure to post audio of advisory committee meetings online and failure to respond to an immediate disclosure request in a timely and/or complete manner. I would just like to read the section from the complaint committee's recommendation. Upon review of the complaint, it was found that the administrative code does not specifically require subcommittees to post audio recordings online. Administrative Code Section 67.16 states that each board and commission enumerated in the charter shall record the minutes for each regular and special meetings of the boards or commission. The meeting in question was not created by the San Francisco Charter. Additional discussion occurred regarding the future need to amend the Sunshine Ordinance to specifically address posting requirements for subcommittees of charter-created boards, committees, and commissions. The committee believes that the San Francisco Arts Commission made a good effort to make agendas, minutes, and audio recordings available to the public. The requested documents are available upon request if not posted online. In regards to the immediate disclosure request for a CD copy of the audio recording, the San Francisco Arts Commission did respond. However, delays occurred due to requests for payments to cover the cost.
Thank you. So, Member Hapner, would you like to speak to this one?
Sure, and maybe you can help me recall some of this, because I remember feeling a bit more ambivalent about this than is reflected in the order. And with respect to whether the subcommittee is obligated or is subject to the minutes and audio recordings requirements, I think that that's a more open question than the order indicates at this moment. My reasons for that are that the SF Arts Committee is a policy body enumerated in the charter, and the subcommittees in question are created by an initiative of the SF Arts Commission. I think that there are arguments to be made on both sides, but looking at Section 67.1 of the Sunshine Ordinance, the findings and purposes, the latter portion of subsection G says, however, when a person or entity is before a policy body or passive meeting body, that person and the public has the right to an open and public process. I see that recommending that even if it is a passive meeting body, and the subcommittee in question here would be a passive meeting body under subsection C of the definitions, that the public has a right to an open and public process. I'm not satisfied that subcommittees are exempt from the minutes and audio requirements just because they are subcommittees and not created in the charter. Does my thinking make sense? I mean, the SF Arts Commission is created by the charter. The subcommittee is created by an initiative of the SF Arts Commission. So does that make it exempt from the audio and minutes requirements? I'm not sure, and my preference is based on the policy enumerated is that it should not be exempt. However, the subcommittee in question, and the reason why we did not find a violation, is that the audio recordings were made available on a CD. And that audio recording was produced in a timely manner. So we did not find a violation. But the question of whether the subcommittee is subject to the audio and minutes requirements is open.
And I think that historically I think we've been not holding subcommittees strictly to that, Member Hepner, although in the spirit of the ordinance, we should. And I think this is one way the ordinance should be strengthened to remove ambiguities about that. Member Pilpel?
I think I agree with both of those comments. I think Chair Washburn has been pretty clear and consistent over a long period of time in your view that subcommittees of charter boards and commissions should both keep minutes and make audio recordings of meetings. It's I think it's at best ambiguous as to 67.14B and 67.16 and how both the recording requirement and the minutes requirement apply to subcommittees of charter boards and commissions. Clearly, those requirements apply to the board and commission. Whether it applies to committees thereof is less clear, and there's other language in the ordinance where committees thereof are referenced. So it's arguable, and I think it should be straightened out one way or the other in a rewrite. But in the current language, I think it's ambiguous, again, to the extent that the commission is keeping minutes and making an audio recording and making that recording available. And I don't see any requirement in the ordinance. Well, excuse me, there may be a requirement under the Mercury amendment that audio recordings be posted online, but there was nothing in the original ordinance on posting. In any event, to the extent that they are making these records, both the minutes and the recordings, and making them available on request, then there's no violation. So I think to that end, the committee recommendation is sound. But I think we can have further policy discussion on clarifying those sections.
Right. Yeah. And I just don't want to create a system where we're incentivizing important decisions and important discussions being made or taking place at subcommittee hearings, and then those resulting in recommendations to, a policy body that's created by the charter and that is subject to these requirements. Instead, we should, technological hurdles may be the biggest reason not to require this, but technological hurdles aside, there doesn't seem to be any reason why subcommittee hearings should not be subject to the audio and minutes requirements.
And I would only add to that the availability of digital recording devices is so easy now in ways that wasn't available 15 or 20 years ago, and uploading that stuff and all of that. And I think this is also why both these recommendations that we're hearing now are recommendations from a committee on which we're taking public comment before an action, and the same thing would apply to issues at subcommittees that then get to a full charter board or commission, whether it's the Arts Commission, Rec Park, or anybody else.
Through the chair.
Member David?
Yeah, I'm just wondering, has a separate file been opened on this underlying issue for compliance and amendment subcommittee to explore this, the underlying question?
No.
And is there any reason for us, is there anything stopping us from opening a separate file so that we can have a broader discussion on this issue?
There's nothing to stop you from opening a hearing file, but I would probably suggest this be something that the Rules Committee
fine.
Take up and...
Compliance and amendments. It's an amendment. It would have to occur via an amendment to the ordinance, which has to go back to the voters and all of that. So I'm not saying we shouldn't have the discussion, but we could either have that small discussion or various issues related to the ordinance.
All I am suggesting is that a separate file be opened and sent to the appropriate. I would leave it to. I would feel that the Chair Washburn could send it to the appropriate committee, but it does seem like an issue that is ripe for discussion, and I would like to see a separate.
So it could go to Member Hebner, since you've opened this up. This is something a file could
and
be
opened. Made my mind up.
This file could be opened up and in compliance and amendments. I'm not sure of how that works, but I know.
I will open the file.
Okay.
It's just a matter of what is the objective of the file. I will speak with the chair regarding that, of the compliance and amendments committee.
Okay. All right.
If it's helpful...
He's the perfect one to do so.
If it's helpful, I can draft a draft memo like I've done on several of these items that we'll talk about later that we could discuss to encourage that.
Why don't we leave it with Member Hebner, since he brought it up, okay?
Or we can talk about it. So.
Sure.
All right.
So with respect to the order of determination, I'm sorry.
So do we have a motion? I'm lost.
Is there a motion to accept the recommendation of the committee?
Okay.
So moved.
Second.
All right. So is there any public? Ms. Trudeau.
Okay, what you see in the screen in front of you, it's called the Advisory Committee of Cross-Examiners, and what you're seeing are handwritten notes under different people's handwriting. So I don't believe they even meet the minimum requirements, first off, for meeting notes. So rather than, waste a lot of my time by saying, well, do the minutes meet the minimum requirement and filing a complaint and bantering back and forth, if you could add all this together, I think it would be to a lot of people's be helpful to a lot of people. Basically, they changed the screening criteria for these street artist people. It's a 5-page document. Membership is seriously down. It should be 450 people. It's more like 350, I believe, now. And these criteria changes began at this committee. When you have no audio and you have these kind of minutes, how is anybody supposed to know, even if they're looking, what's going on? Imagine what it's like out on the street where well over 3/4 don't speak English. They speak Spanish or Chinese. I myself received a verbose letter from Howard Lazar 2 days before this meeting, calling me in to bash up bottle caps. 2 days is not sufficient time to get somebody in there. I sent a PDF document to the commission secretary. I don't know what happened. I didn't go. There wasn't enough time. I had something else to do. So as far as drafting a memo, I think it would be good to many people because these criteria changes went all the way up to the full commission, and without any public input, without anybody knowing about it. And these same advisory people apparently are out on the street actually screaming at people. They don't know what the criteria changes are. And to get these notice of violations without being told what the new criteria is ridiculous. I got one myself. It was 18 pages. There was no reference to anything. I don't know what the guy was talking about. And my response basically was, you haven't given me enough information to respond. And then came the 2-day notice to go in and bust up bottle caps. It's kind of ridiculous in a normal world, but you can understand that there are over 350 people that make their living off this kind of thing, and it would be helpful if people actually had some real information. 3 different people wrote these minutes. They're 3 different handwritings. And when you consider it took me 4 months to get one audio, it's kind of a little bit bad. So that's it. Thank you.
Thank you. Is there additional public comment on the motion? Seeing none, Mr. Young, would you call the roll, please?
On the motion to accept the committee's recommendation, Member Rummold. Aye. Rummold, aye. Member Winston. Winston absent. Member Wolf.
Aye.
Wolf, aye. Member Copra. Copra absent. Member Pilpil.
Aye.
Pilpil, aye. Member Hepner.
Aye.
Hepner, aye. Member David.
Aye.
David, aye. Member Fisher. Aye. Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland. Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. That motion passes. Item number 17, file number 14117, complaint filed by Michael Petrellis against District Attorney George Gascon and the Office of the District Attorney for allegedly violating Administrative Code Sunshine Ordinance Section 67.21, 67.25, 67.27, and California Government Code Section 6253 for failure to respond to immediate disclosure requests in a timely or complete manner. The complaint committee determined that the Sunshine Ordinance Task Force has jurisdiction and recommends that the task force find a violation of Administrative Code Section 67.27 for failure to justify the reason for withholding specific records.
All right, at this time, Member Hepner, would you explain what happened at the complaints?
Yes,
the complaint
though
committee.
I may rely on you to help me fill in a couple details that I don't think are in the file and not necessarily reflected in the order of determination. This was an interesting matter brought by Mr. Petrellis with respect to a party, a fundraising event that is on page 664 of the packet, is the flyer for that event. And the flyer reads, "You are invited to a fundraiser to re-elect District Attorney George Gascon," with a date and location, and it's hosted by Assistant District Attorneys to re-elect George Gascon, with a list of whatever, presumably ADAs, about 15 of them listed at the bottom, and he requested all communications regarding this this event. If I remember correctly, there was an assertion of privilege over documents that had been withheld.
A document, there was one email that was located, and there was an attorney-client privilege as it relates to that particular document.
Point of order. We'll let you know when you can.
I apologize.
I did look to the respondent, and that was a reflection of my sort of vague memory. So. I probably caused that. But in any event, there was skepticism on behalf of the complainant that there weren't more interoffice emails related to the planning of this meeting. And there was some skepticism regarding whether private emails were used for a public purpose in this regard, and whether those communications should have been produced to the extent that they existed, and that was unclear. There was evidently one document that was withheld pursuant to a privilege. We determined a violation based on a lack of proper justification being provided for the withholding of that document, and that. And then I recall that we requested that the district attorney revisit whether a privilege log could be produced with respect to any responsive documents, and the answer to that question was left open. And if Chair Washburn has a memory over...
Yeah, as you're talking, I'm remembering more of the details. So... Mr. Petralis was at first, just incredulous that there weren't emails about this party, except if there had been, that would have been a problem for the district attorney's office, because that sort of activity shouldn't be happening using the government's emails and any of the government's time. So it's nice if there wasn't any. So that was one issue. But the issue finally that we found, there was a problem with providing justification, as must always be done when something is withheld. There may be a perfectly good reason for withholding it, although in this case we're wondering, attorney-client privilege over a party, we found that a bit hard to justify, and we just wanted more. We thought there had to be more in this instance. So, am I recalling this correctly?
Yes, you are. But I think that it might benefit us to ask a couple questions of the respondent since he is here, and I don't see Mr. Petralis here. But the communication in question, was that an email from the ADA's office to the city attorney's office, if I remember correctly?
So there's one document, and by the way, good evening, everybody. Alex Bastion. I'm here on behalf of the San Francisco District Attorney's Office. For starters, there was one document. As far as the document itself, it was an email. It is actually barred, given the attorney-client privilege, and because of that exemption. Other than that, there were no other public records that were located, and that email was an email from the city attorney's office to the district attorney's office.
Okay.
Member David?
Yep. So I was present in the audience for this conversation that night, and I thought I was here for another case, but this one I thought was particularly interesting, and so I think if I think you guys have done a really good job of summarizing it. If I might kind of take a crack at kind of where I, just sitting in the audience, was kind of thinking, where my head was that, so it did not strike me as unusual or even necessarily anything wrong with assistant district attorneys on their own time at home putting together a party for their boss, George Gascode, right? Like they just by being an assistant district attorney, you do not give up your right for free speech or to support a person as long as you're doing it on your own time. And it almost where I think we're all struggling is that. So then, why was there this communication between the district attorney and the city attorney, right? Like if like that on its own, if everyone was like, listen, we all did this on our own time, with our own private email addresses. Like I think that when I sat there, I was thinking like, well, what possible legal advice could the city attorney be giving to the district attorney's office if this was all being done off the books? And I think that's like that just those two things are hard. It for me, just sitting there, that was hard to reconcile, right? Like one or the other, like both seem to be, that just seems to be inconsistent. Is that a fair?
Yeah, that's what we thought. Good for you if there's no responsive emails. Mm-hmm. You would be in more trouble. Yep. But what is this mystery document? And you didn't give Mr. Petralis any explanation one way or the other, which that was a technicality. Well, not a technicality, but it's 67.27. But we wanted to know with the what is the log that the privilege log, could that tell Mr. Petralis something and us something? Because right now we're wondering, like Mr. David, what was that all about?
Let me get to.
It was a party, for goodness sakes.
Sure. If I can respond to 3 different points that were made. The first point, I was sitting right here when an email was provided from the fire department that had confidentiality written on it from the city attorney's office, and the response was, "Hey, are you waiving your attorney-client privilege?" So in terms of why something like that would not be provided, I mean, I was sitting right here. I think it kind of speaks why someone would not provide a particular document that may be attorney-client privilege from one entity to another, because you would in fact waive that privilege. So that's something that I think answers that question. Regarding,
please keep your thought. I do think that there is a difference though, because where the fire department was responding to an issue that was clearly taken up during fire department business.
Sure.
Right. And so I understand what you're saying, and and I'm not saying that you should be giving I'm in no way suggesting that the district attorney's office should waive its attorney-client privilege. What I'm saying is that I'm having a hard time in my mind coming up with a reason why a private party is why there needs to be an assertion of attorney-client privilege over a private party. Please,
I can give you an example. So,
please,
say they found out that all the employees had planned this fundraiser and had been doing it off the books, and they said, hey, maybe I need to check out with the city attorney's office whether this is kosher, whether this violates any campaign finance laws. And so that communication could very easily be privileged, and without speculating about what's actually in the email. That is a entirely logical explanation for what's in this email or why they would assert privilege.
That is super helpful.
Without revealing.
Right. No, but that's great.
I have not seen the email.
Sure. No, but thank you.
Member Pilpel.
My answer to that is yes, but so assuming, okay. It sounds like there is one email that's at issue. You're claiming that there's an attorney-client privilege. You're the client in this case, not the attorney, right?
Correct.
Okay. And that you're not waiving the privilege. So, yes, it is theoretically possible that it's of the nature that you described. Are you actually familiar with the particular email that we're talking about?
I'm familiar with the email.
Okay, so you've read it, for example?
I've read the email, yes.
Okay. Are you able to discuss more generally the nature of the thing without discussing the actual advice?
The issue is, I would like to be here and explain to you really that I would like to get into the particulars with you, but in communicating with a variety of entities, waiving the attorney-client privilege is something that sounds like is a very important thing and a very big deal. So whether it's something very minuscule...
Well, it is, but it's only specific to that communication. If you waive the privilege on a particular communication, it doesn't expose your entire office to blah, blah, blah.
Sure.
And discussing generally that it was advice about something or whatever without discussing the advice itself, in my opinion, doesn't waive the privilege. It's the actual... It's divulging the advice itself that waives the privilege. If you say, we actually got an email giving us advice about blah, 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 generally, I can't tell you what the advice was, but yes, in fact, that was the email.
Well, facts, you can waive the privilege for facts, right? So if there are confidential facts that were communicated, I mean, any disclosure
facts are different from advice.
Well, right, and you can waive it for advice. I mean,
So the
privilege protects facts and advice.
Right. So there are ways to slice it, but I think I would have been more comfortable with an answer that the Re-elect Campaign Committee, a private entity, communicated with the city attorney and said, what are our obligations relative to this event that a bunch of folks in the office have organized? I have more difficulty with one office communicating with another, potentially related. Presumably, whatever this was, it was related to this event. So it wasn't something about a criminal matter or some public records issue or da-da-da. It was actually about this event. And that's and coming into this a little late, that's the struggle that I'm having.
It's kind of different in that the city attorney's office is the attorney for all the agencies in San Francisco. So just like how the Sunshine Ordinance Task Force has a city attorney, the district attorney's office has a city attorney, every other entity in San Francisco has a city attorney. So as it relates to communicating with the city attorney's office, any office, as it relates to any legal matter, would do their due diligence in reaching out to their attorney, or in the alternative, the city attorney's office would be in communication with that particular office, and advice would be provided. Now, as far as attorney-client privilege goes, my understanding is that it's a slippery slope. You waive it here, and theoretically, you can waive it in the next situation, or in the following situation, or it sets a precedent. Regardless of...
I think it's all case by case.
Sure. So. Regardless of it, something very minuscule, if it is barred by the attorney-client privilege to talk about, is still going to be barred, or in some regard, barred by the attorney-client privilege. As far as this particular incident, we're talking about one email, one document. It was a communication from the city attorney's office to the district attorney's office. And I think that in the greater scheme of things, I wish, in the greater scheme of things, that's the purview of what I can say. As far as the privilege law goes, we are obligated to provide, as far as the good government guide goes, nothing in the good government guide indicates that there's a necessity to keep a privilege log. If there was a public record, if there was in fact a privilege log, then we would be obligated to provide that privilege log to the person who is asking for that. As far as the privilege log goes, too, with great deal of respect to everybody here, it sounds like the city attorney's office doesn't keep a privilege log. It sounds like many other entities don't keep a privilege log. So that, in essence, is not even in the good government guide. So as it relates to the privilege log, that's all I can really say about that. There was one other issue that was brought up.
Yeah, sorry for interrupting you earlier.
Yeah, I don't remember. I apologize. I don't recall what the third issue was that was brought up. Was there any other question?
I just had one follow-up. And there is a way within the ordinance to get at something that's equivalent to a privilege log, but I'm not going to talk about it.
Correct. It's a little, yes.
Is there a way, or would your office consider releasing a redacted version of the email so that the advice itself wouldn't be disclosed, but you've asked us for something, here is something, have a nice day, and who it's from and who it's to, all the metadata, for example?
So let me just say this. I'm fairly
An
confident.
opportunity, you've got it.
Yes, I got it. I'm fairly confident that many of you have received either an email or sent an email to an attorney. And I'm jumping to a conclusion there, but all of those emails at the very bottom usually have a block, or at the very top have a block, and it says attorney-client privilege, attorney-client communication. This is not for public consumption. This is not for the public. If something has that very basic line on it, it falls under the attorney-client privilege. Whether it's something that's a small little issue or something else, if it has that attorney-client privilege block on it, and if it involves something that is advice in nature, it falls under the attorney-client privilege.
But what I was suggesting earlier, and then I'm done, is that in this case, that's why I asked, you're the client.
Okay.
So you hold the privilege, and your office and your boss, Ms. Berry. Ms. Berry.
DeBerry, yeah.
Yes, DeBerry, sorry. And District Attorney Gascon could decide to release all or part or redact some and, get us closer to a place here. If you want to be able to talk about it, they can say, you know what, we are willing to say this much about it, which is more than 0, which is sort of what you're saying now. And they can tell you to do that. They can authorize that. We can't compel you to do that, but you guys can think about that.
Okay.
You should think about that.
We'll do, sir.
And in this case, the matter was that Mr. Petralis was told that there were no responsive documents, and then he was told that there was an email, but he wasn't given a reason for why it wasn't divulged.
I respectfully disagree with that exactly. What was exactly said is there were no non-privileged documents responsive to his request. So there's a very big distinction there. Mr. Petralis sends numerous public records. And the standard response for when someone has no responsive records to their request is exactly what you said. In this particular case, there was a different response. In this particular case, from my memory, the response was there are no non-privileged documents pursuant to your request. So, with respect to that, I understand in terms of semantics and in terms of words, there are only 3 words different or 4 words different, but those words actually signify quite a lot. And Mr. Petralis, being the person that he is, that always has a lot of public records, I think he really noticed that differentiation, as well as evidenced by his emails subsequently to that as well. So I just wanted to clarify that slight difference
Right.
there.
It's just in the context of this particular records request, it was a curious response. It got all of us like, this was a party. What are you talking about privilege here? And so that's where we went with our thinking, and that's why we said you need to give more of an explanation under 67.27 than you have. I want to move ahead, but Member David, and then.
I just have to say that I'm a little bit betwixt and between on this one, because I do think that by the absolute letter of the law, the way that you said that there was, as you said that there was a record, and that you gave the reason that you weren't going to produce it. And you cited attorney-client privilege, which is called for by the Sunshine Ordinance, to give the reason that you're not going to do that. I think the meta picture, the optics of this, is really, I think, what's concerning. Is the underlying concern? Is the optics? Is right. Like the city, we all agree the city attorney is not the attorney for the committee to reelect District Attorney George Gascon. Right. Like so that's the concern of the optics.
I get it.
And so I just want to. So I honestly don't know where I come down on this particular issue because of that issue, or in this case because of that specific issue.
Let me try to help you, if I might.
Sure.
So I'm just comparing in our packet. I actually like evidence in our packet. It's really cool and helpful. The December 10th letter, page 663, and I think it's duplicated elsewhere. You've seen all these materials?
Yeah.
Compared to the December 17th letter to us, right? The December 10th letter, as you summarized, we do not have any non-privileged records responsive to your request.
Correct.
Okay? That may be factually true, but it's a sort of short statement. The December 17th letter's got a paragraph. We have completed a search and found no non-privileged public records. Please note that we have withheld production, and you cite bases for that. Sure. If that paragraph from the December 17th letter, Todd, had been in December 10th letter, we might not be sitting here talking about this, because that's probably, regardless of the optics and the justification for the withholding could very easily have been in the earlier letter. Sure. And it's just that missing piece that may well get you a 67.27 violation here. You can still think about what I suggested earlier about releasing all or part or redacted, but at a minimum, this explanation for the withholding could have just been dumped in here. We see versions of this all the time. This is nothing new, and you guys do versions of this as well. So to Member David, that's the help I was trying to suggest. They could have done it a week earlier.
Member Romold.
Also add that the attorney-client privilege, and it looks like you've invoked other stuff here, like work product, California rules of professional conduct. But in any event, those privileges, they aren't blanket privileges, right? They apply to confidential facts, or they apply to legal advice that was provided. But they don't necessarily apply. And, I can envision a world where they apply to the date of an email or who sent it. But, it's not automatic. And so for you all to just stamp something privileged and say the whole thing is exempt, that isn't a particularly persuasive justification. And I don't think it satisfies what the ordinance requires either.
Sure. And I'm sorry, we have seen heavily redacted emails that are like, Alex Bastian at the top, date sent, and everything else blacked out. We've seen those, and we have, in some cases, said, it would be nice if there was more, but, you redacted it, and if you had a basis and explained that, cool. It may well be that the header information or some header information from the subject communications could be released and doesn't violate any kind of privilege. So
you've seen that from the city attorney's office to the entity?
From the city attorney's office, from departments to people, all over the place around here. Yeah. So redaction, is not...
Sure.
That's the whole thing about redaction. It's not absolute and it's not everything.
Sure.
You can pick words. You can pick phrases. You can black pen. It's lots of fun. Never mind.
Can I ask a quick question? Was there any additional follow-up with Mr. Petrellis since the hearing at the Complaints Committee?
On the what committee?
When we heard this at the Complaint Committee, has there been any other communication between? Okay.
No, he has not reached out, and I haven't. I did talk to him outside briefly. He basically came up and I guess wanted to shake my hand, and I shook his hand, and he made a couple statements, but.
Yeah, I think I remember that Mr. Petrellis was grateful for the discussion that had taken place and was satisfied with that violation, and then it was, copacetic from there out.
I think we are going to have a further discussion about social media, because I know one of these pages is that Mr. Petrellis was blocked from following Mr. Gascon. And I suspect when we get into social media, how the city and city officers act with social media will get talked about, and whether or not you can block a member of the public from following somebody. I don't even know what the hell that means, but I'm sure it means something.
Well outside of our purview.
Well, maybe not. No, we've talked about getting into email and record retention, and we asked to discuss social media. So it may not be out of our jurisdiction.
So can I just ask a hypothetical question really quickly? Hypothetically speaking, if something occurs and then the city attorney's office provides some kind of advice on something, hypothetically speaking, that is something that you're saying in their capacity as your attorney, you're saying that that is something that attorney-client privilege may or may not apply, or if it does apply, there should be a privilege log, or is it something that should be redacted and turned over in some capacity?
Member Romold, Member Hebner.
So I think it's fine to say that when you're communicating with the city attorney that, there may be attorney-client privileged information that's exchanged, but it's not the case that it is all communications are automatically privileged and privileged in their entirety, right? So if you are going to claim a blanket privilege for an email, you have to have a very full justification for why nothing at all from that email can be released.
Okay. Thank you.
All right, at this time, I'd like to hear a motion to accept the recommendation from the complaint committee.
So moved, and then I guess we'll also figure out, I think this is the first time we're finding a violation. No, it's not the first time. If we find a violation here, what happens with a potential referral?
Compliance
I will
with the-
write an order determination, and it'll be up to the chair as to whether or not any additional action is
Right.
needed.
Okay, all right. So I have a motion to find a violation. Do I have a second?
Second.
And
There is no
there any?
members of the public in the room.
Okay, all right. So would you call the roll on the matter, Mr. Young?
To find a violation of section 67.27 and subsumed with that is finding jurisdiction.
Yes, the motion is to accept the complaint committee's recommendation to find violation of Sunshine Ordinance Section 67.27 for failure to justify the reason for withholding specific records. On that motion, Member Rummel.
Aye.
Hold, are we splitting the question? Are we?
There is only one question.
No, it says 67, 21, 25, and 27.
But the recommendation is for 67.27 only.
Oh, I'm sorry. Thank you. Thank you. All right.
Rummel, aye. Member Winston, Winston absent. Member Wolf.
Aye.
Wolf, aye. Member Copra, Copra absent. Member Pilpel.
Aye.
Pilpel, aye. Member Hefner.
Aye.
Hefner, aye. Member David.
No.
David, no. Member Fisher. No. Fisher, no. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. The motion passes to find a violation. Are there any instructions from the chair?
Member Hebner, what do you think?
I think that the discussion was at the complaint committee was sufficient. I don't think that this needs to go back to committee. That's my and I think that the violation is to preserve the fact of a violation, and I don't think we need to follow up on this.
Okay. Something else like this comes up, we might do something further, but I think this was a
Right.
good discussion and
Yeah, I think, yeah,
got stuff to think about.
we understand each other's ways of working better. Okay, so thank you, Mr. Vessian.
Thank you all for your time.
Thank you.
And we got you out on time, right?
Yeah, thank you very much. I'll be honest with you. I look at my car. This is what I've been dealing with today. It's a total loss. I still found a way over here. You guys can see that?
Can't see it.
Oh, here. I mean, is it over? Yeah.
Yeah.
Chair Washburn.
No.
Permission to approach.
Yeah. I like to.
Yeah,
Oh, shit.
Total loss. I mean, I was like, I didn't get into a.
Could we maybe take a recess so that we're off the record? Yeah, hold on. Could we maybe
Would you like
take a
to
recess?
Yeah, we're going to take a recess anyway to eat and stuff.
No, I was sleeping. It was like 3:40.
All right. Oh.
Oh, no, 18, excuse me. 18.
We're done the case. No, we aren't.
We are currently on item number 18.
Okay, the regular meeting of the Sunshine Ordinance Task Force is called back into order at 6:47.
Item number 18, file number 14108, complaint filed by Sadie Kamen against the San Francisco Planning Department for allegedly violating Administrative Code Section 67.15 and California Government Code Section 54954.3 A through C for failure to provide adequate opportunity for public comment during Planning Commission hearings. The complaint committee determined that the Sunshine Ordinance Task Force has jurisdiction and recommended that the task force conclude the matter as no violation of the Sunshine Ordinance has occurred. I believe the complaint committee determined that the Sunshine Ordinance does not have any provisions in it regarding setting specific times for hearings to start or for public comment. However, it was of interest to the committee, and we have set a hearing to discuss this matter for the April 1st, 2015 meeting of the Sunshine Ordinance Task Force to discuss the issue.
Yes, Member Hepner, would you tell the others about this?
This was a really interesting issue. I mean, there was no technical violation that we found, but the issue was on the topic of encouraging openness and accessibility, particularly accessibility of local government. The crux of their complaint was that you end up public commenters arrive at these hearings and end up having to wait for so long that several of them are either deterred from coming in the first place or do not, or end up leaving before the item comes up that they're there to speak on. And it's I think that resonates on just a very practical level. And their proposal is to have, they had a number of proposals. Among them, have the committee or the department that's holding the hearing set approximate times for when items will be heard and approximate times then for when public comment on those items will occur. And starting at page 682 of the packet, they put together a pretty impressive presentation. I'm not really, going to speak to the integrity of their system for putting the statistics together, but they called through something like 9 years of planning commission hearings and put together the data showing that the median length, for instance, of a conditional use permit application is 20 minutes, and that at the 85th percentile, it's a 60-minute hearing. So they've done the same for large projects, and they used the example of Park Merced. Any item containing Park Merced is going to have a median length of 90 minutes, and at the 85th percentile, 150 minutes. So essentially, they're just trying to demonstrate the predictability of how long certain items will take. And with the idea that these committee hearings, the people who hold these committee hearings have a lot more information than does the public, and that it would behoove the committees in question to make those estimations so that the public can more easily access and speak in public comment at these hearings. I really encourage people to look through the packet. And for instance, in particular, some of the visualizations that they put together are fun to look at, starting at page 689 of the packet. I don't know how much we can do, but I thought the presentation was compelling, and one of the more exciting things that I've seen in terms of being proactive, proactive policy measures that can be taken.
And I want to say that these were young people who had taken this on, and they had other interested parties comment, and I was very impressed with their diligence and their ideas. And I don't know what we'll be able to do, but I think it's something to talk about. This is a problem with so many commissions, and if we could figure out a way to make it easier for members of the public to participate, we're doing our job, and I think it's an opportunity for us to be creative. And the planning department, or the planning commission, was, they were interested in what was happening, and they might be a good place to start, since they deal with with matters that really touch a lot of neighborhoods. Member Wolf?
Sorry.
It seems like this is essentially a full citywide issue, and although they've been able to do some research on that, it seems like there's probably a few different ways to explore changing the whole paradigm of how the public reacts. And it seems like, although we have no authority to actually do something, it does seem like the type of thing that we could spend, some time with, hearing other proposals from other entities outside of this particular group, and really sort of see what can come up, and then deliver that as a document to the appropriate people to potentially sort of change the way that public comment is dealt with. This is a big issue, not only in San Francisco, but across the country, it's being discussed of how to do this better, and there's a lot of resources that we could tap into to really explore that.
Yeah, I think this is an exciting opportunity for us. It's a chance to be creative and potentially solve a lot of problems. I think it's kind of at the heart of what this task force is about. You know, we spend a lot of time with hearings and finding violations, but one of our big charges is to help figure out ways to have a more open government. And it was really fun to hear the presentations, and the young people were really excited to be there. And yeah. Remember, David, you saw this.
This was the issue that I came for the meeting for, because I thought that, I'd read about it in the paper that day, and I thought it was interesting that they were bringing this to the task force. And I think both you and Member Hepner did an outstanding job of really complimenting them on the kind of meta-analysis. Like, they really did their homework. Like, I don't want to speak to the accuracy, but the presentation that they put together was really, you were like, wow, like it seemed, they gave the appearance of having really done their homework and really kind of laying out that, if the word mission is in the planning department, we kind of know the range of how long that meeting, that issue will go. Like, and they really broke it down. And, I was saying that, and I think the same comments that they were trying to get across was that we lack, in order to get a diversity of public comment, just everyday working people who are like, there's an issue that I care about at City Hall, right? 4-hour windows of when you might be able to give public comment are unrealistic.
Right.
Right? And that if we can narrow that down, it's unrealistic to expect people to show up to leave work for 4 hours. And that if there's any way to narrow it down, and I think they used the Planning Commission because there were, I think there are hot button issues, that it was easier to kind of delve into the information on that. So, it's an interesting, I think we're going to open a file. Are we opened a file?
It's going to be on the our next full task force meeting. Yeah.
Yeah, but I think it's a phenomenal issue for us to try to see if there's a way for us to tackle it.
Yeah.
Yeah.
Vice Chair Hyland.
I'm just curious, were these a group of students?
I'm not sure. Remember,
No, they are. I know a couple of them from other realms, and they are young organizers who, go to planning commission hearings.
Okay, and the fact, just guessing by the name, ethnic diversity springs to mind from the names that I see listed here. I wasn't there at the meeting, but I know a lot of us talked at the beginning of this term of the SOTF of rebranding. This might be a nice opportunity to kind of jump on that bandwagon. Would we even want to, as well as noticing this April 1st discussion, would we want to release something in the press about this? Would we want to be more proactive, or can we do that? I guess another question.
I think we can. In the past, we have issued press releases primarily about the complaints we were hearing, violations we were finding. But I think after the April 1st meeting, depending on where we're going with this, I think, this is a project that I think could help the members of the public, city departments, see us a bit differently than they have. Member Wolf?
And just to finish off, one of the other things that we were discussing as part of our amendments to our bylaws or fine-tuning is time limits within files. So this might be a nice lead-off for us kind of looking at our own procedures more closely, kind of tying into this. And I'd love to get analysis of us.
Yeah, exactly.
Invite
right.
them to come and listen to our, but
They were here earlier tonight and they left.
Were they?
Yeah, there was. Yeah, one of the members was here.
Because they were on the list, but they probably, with all the changes we had, they probably didn't want to wait till
exactly.
they might be heard.
Yeah, exactly. Right. Yeah, we have timestamps, so we could do the analysis of ourselves, for sure. Member Wolf?
Quick question to Member Hepner before I make my point. Were the people from there involved with the SF BARF? That's
Yes.
correct? Okay, that's what I thought. I do think that we do need to be very careful when it comes to engaging the press around this issue, that we are acting independently as the Sunshine Task Force around this larger issue and not serving as a tool for SF BARF's campaign by, whether intentionally or not, putting ourselves in that position.
I'm sympathetic to that, and knowing quite a bit about SF BARF and what they do, but I think that we can keep these issues separate.
I definitely think we can keep them separate, but when it comes to engaging with the press on this issue, I do think that it starts to get into areas that can become convoluted pretty quickly.
Maybe we just noticed it normally then, but someone could explain SF BARF quickly?
Yes.
Well,
inquiring minds want to.
I might not be the most objective source on this, but SF BARF is an entity, is a group that attends planning commission hearings to encourage development, and they market rate housing, and they really urge a build approach to housing issues in the city, and that's all I'll say.
And I was hoping for something more colorful.
Off the record.
Member Pilpil, perhaps.
Yes,
Chair
Member
will let you-
Pilpil.
For once, I actually don't have anything colorful in this. I agree with many of the comments that were made. As much as I've sat at home for the last week and a half and been terribly depressed, this actually is kind of interesting and exciting. And in some ways, I'll disagree just in part with Member Wolf when he said this is not necessarily something we do. It actually, I think, really is.
That's not what I said.
Oh, okay. I thought maybe it's my hearing that
He's just being. Yeah.
One of the powers and duties we have in 67.30 is to advise departments of practical ways to make the thing work. And I read that really broadly in not just the letter of the ordinance, but in sort of making meaningful public participation in city government a reality. And frankly, it's really not a reality. And the more we can make it useful for people, I mean, this can be as simple as, for our 26-item agenda or anybody else's, for a meeting that's likely to run more than 2 hours, to have breaks and say, this is now the 6 o'clock calendar. So if you're this item, you really need not show up before 6 o'clock. If you want to, that's fine, but we're not going to hear the item before 6, and so, et cetera. And the Planning Commission used to do that routinely. So they had a noon calendar, a 1:30 calendar, a 5 o'clock calendar, an 8 o'clock calendar, and people would know that for their item, they didn't need to show up early. The board does that occasionally, but not regularly, and commissions don't do that generally. I mean, that's the kind of thing that we can recommend. It's pretty easy, and whether it's something like the silly memo that I did that we'll talk about later on, or other things, I think we should be doing a memo at least every other month to departments about some issue related to sunshine and ways to make the thing work. Really practical tips. Each commission should have a binder on the table with their packet, right? We've got one, some do, some don't. I mean, whatever. I'm getting a little farther afield here, but the point is that we can be more proactive. I think the more we don't just deal with complaints, the more things get better around here. And so I look forward to the discussion next time, and I hope that we'll invite these folks. I think I initially looked up their reference, and it was some weird study about blood donors in Australia or something, because it had to do with wait time and queuing and all that. But the way it's been presented tonight, this is interesting. So I look forward to hearing more and for us to be creative about what we do on it. So.
Okay, Member David, and then we'll
Sure.
move on.
Yeah, I kind of want to give the other side of the coin of the, good ideas can come from lots of different places, and that I really think that we should, as a task force, separate whatever one's preconceived beliefs of an organization. If a good idea about, having better access to public comment is brought to us from an organization, that should be the focus of the task force. And, whatever they're doing outside of that, that's not our realm, or so anyway, I don't want to play favorites, and I don't want to play disfavorites because of what one's agenda might be outside of public comment. These people clearly came to this meeting the other night with a plan to be able to give a more predictable public comment schedule that would encourage more participation. And that was my takeaway from that. And I think that fits squarely into our breadbasket. That's it.
Very good. Okay, Member Wolf, and then let's have a motion. Or if you're going to make a motion, that would be great.
I just needed to respond to what Member David said real fast, which is that I don't think that where they come from has anything to do with this. However, when it comes to dealing with the press and sending out press releases, we need to be mindful of the politics involved in our press releases, which is two very different issues from what we do and how we advertise what we do. And the only other thing is that I think that this proposal that's been brought forward is a really solid one, but having worked on a bunch of other elements with some other cities around similar public comment issues, I think there's a lot more other, even further outside of the box ideas that can be brought up, that is why this is worth really doing a sort of focus on this issue. I remember when this issue came up, I was reading the news about it, and I wasn't able to attend the meeting as a participant, but I remember thinking that it was probably a better suited discussion because of the way that they had pigeoned it to be in front of the whole board. But there's no reason that we can't continue this topic as its own item in the future.
Okay, and do I hear a motion to approve the recommendation of the complaint committee?
So moved.
Second.
Okay, and there's no public to comment on the motion, so Mr. Young, would you call the roll?
Member Rummold.
Aye.
Rummold, aye. Member Winston. Winston absent. Member Wolf.
Aye.
Wolf, aye. Member Copra. Copra absent. Member Pilpel.
Aye.
Pilpel, aye. Member Hefner.
Aye.
Hefner, aye. Member David.
Aye.
David, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland. Aye. Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. The motion passes. The motion passes. On this matter, the April 1st hearing, would you like to set a special order to specify a start time for that meeting?
Very good. Well, I think this should come early on in the agenda because
your discretion. We can set a special order for any time you want.
let's take
I was
a-
thinking if you're concerned with work hours, maybe we can set it for 7 o'clock or.
I was thinking after general public comment.
So I like Victor's. I like Victor's idea of 7 o'clock, so that if these people do seem to be. Yes, and so it would be starting now, which would Yes,
So that would allow us to complete our hearings of complaints prior to this hearing.
Okay, all right, 7 o'clock then.
Special order. The hearing shall be set for a special order of 7 o'clock.
Is someone on the task force taking a lead on this? I'm not volunteering, but I'm hoping that we're not just going to say, well, their ideas, blah, 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 that somebody sort of thought through this.
Member Hebner.
You have or you will have a plan for next month?
I was going to ask, are there any entities that you would like me to invite? At this moment, we're inviting the planning department, but if there are any other. Sorry.
Member Wolf.
I think we should invite the people from Democracy OS, which is a nonprofit that's focusing on this issue. They're based out of, they're working out of Palo Alto. They're based out of Buenos Aires, but
all just south of here.
Mm-hmm. We could also invite the League of Women Voters.
I know those people.
I do know those people, yeah. So SPJ?
Yeah, I mean, reaching out to journalists is very different than press releases.
That's what I meant.
Yeah. So as SPJ and through Rick Nee, maybe?
Okay.
If there's anything, any invitees that you would like me to include, please provide it to me within the next week or two.
And people who show up might suggest other people that we can talk to in the future. I mean, this shouldn't be like a one-time 5-minute discussion.
No, we're not going to solve this. We're
Fixing public participation in government, it's a constant,
No, we're going to solve democracy in one day.
Exactly.
Okay.
I'm wary of inviting a whole lot of organizations that would then be expecting a presentation by us. That I don't want to invite a whole bunch of people and then be like, well, so what do you guys want to talk about?
I think we should think about this as an opportunity for us to learn.
Yes.
Yeah, we want to learn, and this is at the beginning of a dialogue that I think will probably then continue.
Maybe we should keep
in
this one
committee.
with the initial parties, and then as we continue it, we can invite additional parties.
No,
as
I don't think so.
Yeah, I don't know. I think we ought to. Member Wolf, yeah.
I think that we really should, and particularly additional parties that have ideas outside of this scheduling, because I feel like what we've done is they have a very specific proposal they would like to see put forward, and I think that it would be very interesting to see other ideas put forward that are from different perspectives.
And then since you seem to be aware of what other groups are doing and what other communities are doing, then if you would maybe be prepared to share some of those that evening, that would be great.
Yeah, I can talk about stuff. I mean, some of the most interesting stuff is what Democracy OS is working on, and hopefully they'll be able to attend and speak to their progress.
Okay, great.
Maybe if members Wolf and Hepner could sort of chat before, so that it appears that we've got some kind of plan for a discussion. I don't know that we need to necessarily take action next month, but to, kind of hear different ideas.
Yeah, and then I don't know whether this makes sense or not, but Supervisor Farrell has a contract with Democracy OS right now, so we might want to invite Supervisor Farrell.
He would come. He'd probably send Catherine.
Think about, through the chair, the structure of this. Sometimes I think the Board of Supervisors has people present to them rather than, although this was framed as a violation.
No, we didn't find a violation, actually.
We're making it a policy issue.
Right, that's what I'm saying. But we should be careful to say that this is a presentation to us. We've been so backlogged that we haven't had that luxury till now. But I think that's the way to, and then, interested, and if we post it that way, we notice it that way in the libraries and whatnot, other parties will see it and we'll.
Oh, okay. So we're asking for a presentation by the group that brought the matter to us.
I think that's an appropriate way of, that way they're not expecting us to have anything prepared in rebuttal.
And Josh, if you have anybody else that could make a short presentation, maybe.
That's where I was getting to. So I didn't want to make it unfair that they're the only ones that gets the mic, but that your other organization also has an opportunity to co-present, if they like, or, we have to be mindful of time. And this will take place between 7 and 8 p.m.
Right.
Can we put that on the agenda? Can we give it an end time? That's not a bad idea.
I've never put an end time on an item.
Might be appropriate in this case.
I think that's the role of our chair, is to bring an item to an end. Putting an end time on it, then.
It's estimated the 95th percentile will be at 8 p.m. Something like that.
Actually, for a long time, we had on our agenda, estimated 5 minutes, estimated half an hour, and then we dropped that because we weren't holding to it. So these are all good ideas for discussion next time.
Mm-hmm.
All right, so we'll be inviting the group that brought the matter to us in the first place to present, which they will be prepared to do, I'm sure. And then, Member Wolf, if you could have your group also present.
Just through the chair, is there any way we can notice it in time for April 1st and say something along the lines of other parties interested in talking on this matter or presenting on this matter, please contact the clerk?
Yeah, who do you want to notice?
Well, if we post this in enough time, other organizations may say, hey, we wanted to say something on this as well or present on this can we jump in? Or do they have to just show up and do, the public comment part of it?
Yeah, right.
It's always at the discretion of the chair to allow presenters to go beyond public comment time.
Would it be worth putting in language like this is the beginning of what we anticipate be some live debate in this area? Interested parties are welcome to attend, something like that. I mean, I'm just trying to keep it very fair.
I would say if you want to jump in and help draft a thing, that's cool. And if people send something to Victor, particularly that could get in the packet, that would be great. And if people show up and the chair knows, you can invite them to make a short presentation and we can do chit chat.
Okay, I want to move on. So,
there you go.
All right.
Next on the agenda, item number.
Did we vote on?
Yes, we did take a vote.
Okay, we did. All right, I'm getting lost. All right, so Vice Chair Hyland, if you want to draft some.
I can certainly help Victor with maybe the noticing language.
Right.
Send me a draft and I'll make it more inclusive. I just want to appear as though we're giving the forum to those interested in the topic and not one particular entity.
Right, okay.
That's all.
And then we've indicated that we'd invite the League of Women Voters, we'd invite Democracy OS, and anybody else you can think of.
Yeah.
Member Wolf, since you know this area.
I mean, we need them to show up in person, not remotely, right? So they need to be San Francisco or Bay Area
Yeah, that would be, yeah.
Okay.
I think we're keeping this, it's a local issue right now. We're soliciting ideas from.
Right. I mean, many of the leading people in this subject matter are not necessarily local around the public, because public comment is not a local issue. It's
Yeah.
We have a small slush fund. We can fly them up from Buenos Aires if we need to.
Oh, no, those guys are in Palo Alto. There's a bunch of people in Estonia that are, in Estonia.
Oh, wow. Okay.
There's a slush fund. We could ask the city attorney for advice. Never.
All right, guys, let's move on.
Item number 19, proposed amendments to the Sunshine Ordinance Task Force bylaws and/or complaint procedures.
So,
I believe at the last
Member
meeting,
Fisher, did you want to, this is your committee.
I believe at the last meeting, we went through it, and there were several members of the task force who wanted to make recommendations for various aspects. However, I have not received any recommendations at this time.
Yeah, guys, when we looked at this, I remember this last month, and everybody said, well, give us a month. We want to look through. We want to make changes. We want to look at it. So it's been a month. So we have two options here. Either speak now or forever hold your peace, or we wait another month and everybody can say, oh, yeah, this month I'm really going to look at it. So comments?
Wow.
Member?
To the chair, I think that this is
not my meeting.
This is a work in progress, so we can always make future changes. But,
Oh, yeah.
But I think it's probably important to get something on the books now.
And one last thing is, remember, perfect is the enemy of good enough. So.
Okay, I read through it. I had a couple of small edits typos that I noticed that I'll pass on. But I think the one item that stuck out for me, and I know Member Pilpel mentioned it, was when to have the officers, the election of the officers. And we've historically done it right after we've all been appointed, which is problematic. And the proposal is to move it to first of the year. So that's like the big change that I can see. The others are kind of cleaning it up to match what we really do. So, Member Fisher, did you want to talk a little bit about the rationale for that change? And
I believe that came from myself.
Okay, Victor, what you want to tell us?
It was just previous. It was previous comments that I heard from the task force at various meetings, in that we wanted to change the annual report time to the beginning of the year, so that members would actually be present who were involved. Would be able to make the annual report instead of having new members just coming on board trying to write a report. And it was my thought that since we were moving that date, we should move everything to January 1st just to be consistent, and in addition to avoid appointing a new president or a new chair when we're first electing or having new appointments to this task force.
Okay. That makes a great deal of sense to me. Other members, your ideas?
Comments?
Member Pilpel?
So on that point, and then we'll move on to other issues. I'm just concerned because there have been a number of instances where a large number of members of the task force have been replaced. And so I'm just concerned what happens if the chair and the vice chair aren't reappointed, and then we've got a break in leadership. It is difficult to go back and create an annual report for the first part of the year. I just think for all of those reasons, it seems in my mind like there's no good reason not to continue to elect at the first meeting after the majority of the members are seated, which is April 27th. I know it's an odd time, but that's our anniversary date.
I believe currently it's, my apologies, I don't recall the section.
It's not actually in the ordinance. Oh, I'm
currently
sorry.
it states July 1st.
Right. I'm sorry. In the bylaws, it's July 1. The ordinance doesn't speak to it. My suggestion would be to change the date to the first regular meeting after April 27th, or a date that's fixed at that meeting. And I think that works. And we can have the annual report be on whatever basis we want, whether it's that basis, calendar year, fiscal year. We've done all of those things over the years.
The annual report given to us by the Board of Supervisors, then?
No. The ordinance just says that there shall be an annual report, and we've done them on different timeframes.
And more recently, it's been
we went to
biannual report.
We did that last time, but we've also done annual, we've done calendar year, we've done fiscal year, we've done term, we've done them all, or not done them, or done them late, but whatever.
Okay,
We could also think about this. I have some other things to say.
We could separate the annual report and the...
Correct.
Well,
Right.
no matter what, this needs to be continued until the next meeting because it requires a post. Our current requirement requires us to post advance notice at the library before we can adopt any new bylaws.
Okay.
And I have not done that at this time.
okay, all right. So any other, I understand your reasoning for, and I think they're good reasons for having the election take place on January 30th. And I think what happened when we were all replaced was an anomaly, and hopefully won't happen again where this body is purged. And usually it's all very much orderly. There's staggered appointments, and people know when they're going to leave or not, and let everybody know. And it's more orderly. That was just an aberration. So I'm of the mind to continue as we have been because it seemed to have worked except for that one exception where everybody was new except Rick and I and Suzanne.
Although I'd say, Chair, that the purge has kind of reset the clock. We're all on the same timetable now, aren't we? So potentially we could have a lot of turnover every 2 years.
Yeah, is that true? We're no longer staggered? We all have the same...
There's only 2 members staggered.
Really? But it used to be like half for a...
I believe that was...
Since the ordinance was amended, it's a 9 and 2 scheme. It's the same date. It's April 27th. 9 of us are up in even-numbered years, and 2 of us are up in odd-numbered years. So members Copra and Hinsey are up again April 27th this year, and the other 9 of us are up next year. And it had to do with the interpretation of the amendments from Prop G and how that squared with the previous task force and when the terms ran. So, in fact, there was a period of 6 months where the task force didn't meet in 2000 because of the amendments and
a simple yes would have sufficed.
Yeah, sorry.
Got it. All right.
But I had other things to talk about here, too.
I know.
Okay, if you could make them brief.
Sure. So
May I have a consensus on that issue, or do we want to keep it on July 1st, or would we like to move it to January 30th?
What's the sense of the members?
So,
David?
so my only, the July 1st date seems to kind of make sense if everything's moving along smoothly, right? But even this past year, right, there was multiple rules hearings until everyone got sat. So if there was a way to word it such that it was like, a full a full task force, as soon as close to July 1st or after, where a full, at least 9 seats are filled of the task force. I mean, something that kind of is a little bit pragmatic, but also kind of sticks with the traditional timetable would be something that I would want to look for reasons that have been obvious over the last couple of years. This task force has been controversial for appointments, and I think that we probably need to keep that in mind as we talk about the leadership of the task force and when we're going to do those votes. And so that I think our bylaws, right, we don't want to handcuff ourselves where we have 6 members on the task force because the Rules Committee hasn't gotten around to appointing the other 5.
Right.
And so
I see what you mean.
Yeah.
Yeah, that makes sense. Member Pilpel?
So my suggestion there on page 733 of the packet would be language that says, the officers shall be elected at the first regular meeting of the task force held after, in my view, April 27th of each year, or at a subsequent meeting, the date of which shall be fixed by the task force at the first regular meeting after April 27th of each year. If any task force office becomes vacant, that office shall be filled at the first meeting after the vacancy occurs. So it says it's either the first meeting, or if the task force says, we're not ready, we're not filled, then it gets continued. But it sort of puts it at that at the May meeting to at least deal with one way or the other.
Through the chair, I guess my concern about that would be, let's just say, theoretically, there's 6 members on the task force, so we can meet, right? And that I would assume that voting for the president and vice president of the task force is a is it substantive or procedural?
Substantive requires 6 votes.
So literally, you would need unanimous vote in order to. So it's just.
So if one person's uncomfortable, then the whole thing gets continued.
Yes.
That's how that goes.
Okay. I'm just playing this out as to what.
And I also want to be clear. I'm not trying to move up or move back the election. This has nothing to do with. I'm just trying. Anyway, I'll shut up. I talk too much.
So is everybody comfortable with having the date be after the first regular meeting after the Rules Committee meets to,
I will find the exact date of the April date where all the expirations occur.
Okay. And although do we necessarily want to, because that could change. Couldn't that change? No, it has to be then? It has to be then.
The date does not change.
Okay, the date. So
Under the current ordinance. If the ordinance changes, then.
Okay, yeah, and put that date in there, and the first regular meeting after that date, and then, or a subsequent date if the task force decides to move it forward. Yeah, the language is there now, but just the date of
Changing the date, yes.
Yeah, okay.
It'll be changed from July 1st to the April date.
Right.
I would just add some sort of language, we also get into situations where carryovers, can happen for multiple years. So I think that there should be some language that the date after the Rules Committee, and it was considered by the Board of Supervisors, right, that the rules, so the soonest date after April 27th, where the Rules Committee has made recommendations to the Board of Supervisors, and the Board of Supervisors has voted on task force members.
Todd?
Yeah, please. Yeah.
In practical terms, I think we're only going to elect officers when people are actually seated and ready to go. And if there are holdovers that are happening, they'll deal with it. And, these are only the bylaws. If these aren't working in a year or 2 years, they can be changed again, and it may be our successors that change them, This is only for the purpose of electing. This is not like,
All right, so moving on from that.
That's fine.
Yes.
Okay.
Topic.
I believe that Member Pilpul had some suggestions.
Yeah, some other quick things. On page 1 of the bylaws, we added contact information
Where
to
are
the
we?
header, page 732 of the packet.
Okay.
Contact information was added to the header in Article 1, but there's no section for that. I had suggested that we include in here how to contact the task force. So I think if we just dump in that language, the address, the email, the phone, the fax.
I would prefer not to, as that there's always a possibility of changes.
Right, but the point of putting it in here is if it changes, then we would change this, just like we're changing the date of our regular meeting because we've changed that. So it's not like City Hall is likely to move. And if that changes, we'll change this. The bylaws, you should amend the bylaws from time to time, which doesn't mean like every meeting, but it also doesn't mean every 10 years. So if it needs to change, I just think this is a good document to include contact information. And I've seen other bylaws around the city where they include that.
It could just be the clerk, SOTF. I mean.
Yeah, it's not that. So that was a suggestion. Did you want to seek consensus on that?
I don't see any objection to that recommendation.
Okay. On page 2, the following page.
Member Pilpel?
Yeah.
You're keeping notes of this, right? Because you could then send this to, okay.
Yeah.
All right.
Article 2, Section 4, the election of officer process to be created. I'm of the view that we don't need to specify in the bylaws how officers are elected. There's a general process that the city uses to do that either you nominate, you don't need a second, there's Robert's rules about that. We don't do secret ballots. I don't think that we need to do anything different or special, and I wouldn't think that it's useful to craft a bunch of verbiage about that. We've had disputes about officers, but we've settled them amicably. And
Is there any objection to removal of that section? I
None.
believe that is acceptable.
Okay. Moving on.
Okay. The Article 3, Section 4, the cancellation of meetings, and for that matter, Article 7 about amendments, I would just include language in there that says notices of cancellation or notices of potential amendments shall be posted in the same locations as notices of meetings.
Sounds reasonable.
So that it's not duplicated 3 times.
Without objection?
Yay.
Okay.
So where are we?
Section 6, setting agendas.
I don't think I had a huge problem with much
Page 734.
the rest of this. Refile records retention.
I am,
Section
in
7.
looking over Section 10, this is at the bottom of the 4th page of the draft. The note that was there about time must be adhered to if a speaker is interrupted by questions, the interruption doesn't count. That's what we tend to follow. I was wondering why this was struck.
I would think that would be at the
I believe
call of the
was
chair.
restated in a different portion.
Oh, okay.
A lot of these amendments were provided to me, and I believe it was restated in a different section.
Made more sense there.
That might have been one of mine, because I think it's just sort of assumed. I mean, I think my thinking was that we lay out a general hearing process here. It's in much greater detail in the hearing procedures, the complaint procedures. And beyond that, the chair has discretion, and,
Right.
If someone says, I'm done, I'm going to sit down, they don't have to stand there for 3,
It is common practice that I do not time interruptions. That is the same for the Board of Supervisors, and it is not written.
Yeah, okay.
And I guess the other thing that I was not crazy about, maybe we'll have some discussion on this, is this whole thing about the minutes not requiring a vote. I think that came up a little bit last month, briefly. All bodies in the city have a vote on their minutes. It's like
I disagree with that statement. The Board of Supervisors and its committees do not vote on their minutes anymore. They use this process.
Well, I talked to Angela about it specifically. I don't know if she got back to you on this. I was told that there's a specific provision in the charter that requires the board to act in a certain way relative to minutes. So there's now some kind of motion that they changed the way they handle it, but the way the board does its minutes, which is really a journal, it's a whole different thing from the way boards and commissions and other policy bodies handle it. So when we hear about minutes at the Arts Commission and at the Planning Commission and things like that, at each of those bodies, there's a set of draft minutes, and they vote on them. They take public comment, and it's an action item, and they are complying with the content requirements of 67.16 and the charter requirements, and it's a vote. And I think if we suggest that this process is okay for us, if other bodies say, well, it's good enough for you, then it's good enough for us, then people will stop voting to adopt minutes, and I think that's a bad road to go down for all kinds of reasons. So I am not with doing this process. I think we vote on minutes, and I don't think that's not working. I think that's actually kind of working the way we do it.
But invariably, there's changes,
and we make those changes, and they get
on the
worked
fly.
in.
So why not? I mean,
but the way we do it, I mean, we can do most of these steps, but I don't think we need to lay out these steps, and I just don't like the idea that there's no vote taken.
Why?
Because I think it's a charter requirement to make a record of actions of the body, and because the content of the minutes are specified in the ordinance, I think a body needs to act to do that and not just assent or not object. I mean, if everything around here were presented as a consent item, and unless you object, we're just going to do it, I don't think that's a great way to run the government.
Through the chair.
Member David?
DCA Cola, would you like to weigh in on this?
I'd actually defer to Victor on this one. You think that the board has changed their method so they don't have to approve? They don't need a...
I was instructed to follow the procedures listed in Robert's Rules of Order regarding approval of meeting minutes. At the last meeting, I did provide a copy of that section. However, this procedure is the procedure listed in the Robert's Rules of Order.
You can go back and talk to Angela on this.
And this is the instruction I did receive from my manager on how to process minutes.
Anyway, I had a specific conversation with the clerk of the board about this. So,
Vice Chair Hyland?
Victor, administrators should provide copies of the minutes to members of the task force prior to the meeting. Does that mean hard copies as we come in, or does that mean by email, or is that left open?
It is open to interpretation, but my interpretation is that when I provide it to you in your packets, that is provision of the minutes.
Okay. And would that be in the online package, the public package? It'll be in there as well?
Yes.
Okay. So we will have ample opportunity to review those minutes prior to walking in here.
Yes.
I think that's fair.
I guess
personally, I'm okay with that procedure, but we can certainly vote on that.
I will check with the clerk of the board regarding this item, and we can make the decision at the next meeting. However, I will leave it in the draft at this time.
Okay.
And then I had a quick question through the chair on item 7. Just backtracking a second, because I think this
Section 7.
Section 7. This is important. The quorum. I don't know if it's just that it's not coming out very clearly, but I'm reading the strike through the presence of a majority of the task force members, and it looks like 6 members is crossed out.
May I ask what page you are?
This is 734, bottom
Thank you.
third of 734, beginning of section 7. 28, line number 28. It looks like members is crossed out, but not 6. So does 6 stay in, or is it all crossed out?
6 days in, I believe the presence of a majority of the task force members, and
The
it's
closed
6.
paren should still be in.
That's what I was going to say. Okay,
Yeah.
so the 6 there would then be consistent with the other 6. Okay, that's important because I mean that's something we can get our knuckles wrapped for.
On that note, really quickly,
Right. That's another
Oh.
purge.
for the next month's review on this, can we just make sure there's a clean copy included
Yes, just to,
in addition to the edited copy?
yeah.
Okay.
Yes.
So I believe, Chair, we were up at section 11.
It's not a big thing, but I think when I last looked at this, the membership and attendance section is like Article 6 near the end. I actually would move that up towards the beginning after Article 1. I think you sort of start with a body, then you go to membership, then you go to meetings. It's kind of weird for me to have like the membership at the tail end and oh, by the way, attendance is kind of important. I would just move that article, but not change the substance. It's fine.
And I just realized I only have a couple of typos. I might as well say them now so I don't have to give you paper. On page 8, this is Article 6, Section 3 holdover. It should be members served past.
One moment, I'm trying to find that spot. Could you repeat that section again, please?
So it's Article 6, membership and attendance, page 8 of the,
Yes.
page 8 of 8. Yeah, it's line 21, members serve past rather than paste.
That got fixed.
Oh, that got fixed?
You
Okay.
got an earlier one.
Oh, okay. And then the 10th, line 26, the task force may amend these bylaws.
Oh, right, yeah, that needs to get fixed.
Okay.
I will make those corrections.
Maybe if we can give Victor the authority to make clerical, non-substantive corrections like that, and we'll do a little review before it gets posted, so hopefully we catch those. Because, I mean, I think that'll become more evident with both the red line and the clean copy.
Right.
So noting that we can make further changes in the future with notice and all of that, I guess I'm prepared to move that we post these proposals for action at the next meeting.
Second.
And there's no public to comment on the motion without objection? All right.
That matter shall be advertised or posted at the public library and scheduled for our next meeting for approval. Regarding the complaint procedures,
Yep.
I believe we can take action on these tonight, but at your discretion, I don't believe there are any special rules regarding amendments to the complaint procedures. Before we get to that section, I wanted to make a suggestion regarding amending continuances. An issue did come up this last week where I did receive a request for continuance from a first-time complainant. However, I had to call in all parties. I believe the Public Utilities Commission had to come in today because I could not grant a continuance, even though I knew it would be granted by the task force. I was wondering if you would consider giving me the authority to grant first-time continuances.
Good idea.
Yeah, I think just letting the chair know and then granting it, absolutely, yeah.
Documenting it and do it.
Sorry, is that before or after the agenda is finalized?
That would be after agendas are finalized.
See, that's where I disagree in part. I think once the agenda is finalized, then I think we have to take action on it. I think
You would still take action.
We can still, right. I mean, I'm sorry, through the chair. I mean, if we're adopting a policy that first time continuances are going to be granted pro forma, then I don't see what is the harm of allowing Victor to inform people of that, and that much like the complaint committees, right? It's brought here as a consent calendar type of item, and we say, yeah, I mean, that seems to make
And the
sense.
respondent doesn't have to appear.
Yeah.
Yes, I feel that my hands are tied where I can't tell the complainant that he does not have to show up after he makes the request. And the same thing with the respondent. I can't tell you for sure.
Yeah.
So you still have to show up. It leaves everybody questioning whether or not the continuance will be granted.
Member Wolf?
Plus, there's this issue that if you're a complainant that really wants to game the system, the balance is shifted against the respondent at this point in time, because if you're a complainant and you know you make the request, you can force the other side to still go to the meeting, but you know that it's going to be altered. So there's a whole bunch of stuff that one could do that I think putting that power in Victor's hands kind of balances that situation.
I think in general, some of the language is good here. There are a couple of blank spots, and we should either figure that out now or do another pass on this. I also think that this needs a red line versus a clean copy, because there are some language issues that, page 741, line 27, if we're striking when, then the complaint committee needs to be capitalized. Anyway, there's just stuff in here. Page 742, if the respondent fails to appear, we should say something. I think that's a good idea. Victor points out correctly on line 32, documentation, we regularly ignore this, delete or modify it. Well,
yeah, I think that,
I mean, I think it's still a good idea, and we need to enforce it, is the point. You know?
But I mean, it worked well tonight, tabling it, when they weren't here. Because
I don't know on the other thing, but on, when a department fails to provide the original request and their response, and it's material to our consideration, I think it's good for Victor to say, we need that, and I'm not going to schedule a hearing until you provide it, you department. I mean, for us to get a half-baked agenda item doesn't help anybody.
Right, but sorry, through the chair, but that also puts the complainant at a disadvantage. That allows the respondent to delay. If the
complainant could also provide it.
No, I understand that. But what you just said is, I just want to be clear. But what you just said is that if Victor could go to the respondent and say, provide all of this documents, or we're not going to hear your hearing.
I think
right,
better,
like that. That's
okay.
Right, like that's like the fine.
Maybe that's the wrong language, but the idea is for us to get a complete, non-duplicated, useful packet so that we can make informed judgments about things.
I think that is. I think it's an ideal. I think it's ideal. I'm not sure that necessarily goes into the bylaws.
Through the chair, could we say
complaint procedures? No?
Excuse me, Vice Chair Hyland.
Could we put something in there saying that put the onus on the respondent for certain documentation, failure to do so may lead to violations.
Right, we find violations for failure to provide these things. I don't think we should not calendar the item until they do what they're supposed to be doing. We need to.
Yeah, so the onus is on them, and we're going to hear it anyway, and if you haven't provided what we've asked you for, that's an additional violation.
I'll add that language, may lead to additional violations.
May lead may lead to violations because we're presuming they're innocent.
To violations.
Yeah.
And maybe a sentence that the administrator shall endeavor to seek relevant documents for purpose of the file from both parties.
I do that with my initial request, but I don't believe I should be the person who decides what is relevant and what is not.
I'm just trying to give you some support so that if they say, why do I have to give it to you, you say, because the task force wants it.
Failure to provide requested documentation may lead to a violation.
And in essence, I do that in a way at this time in which I will not schedule it until I have documentation.
But I think, as Member David's saying, we don't want to let them know that they can delay it by not providing the documentation. So if we just stick to telling them, provide it, it's being scheduled on X date, provide Y, otherwise you might get a violation Z. That's the message you want to send them, right?
No, I think that's true. Yeah. Absolutely.
So.
Yes.
Anyway, I still think that administrator can endeavor, doesn't hurt.
I think he does.
And that brings to the other question that we give them 5 days to respond to my initial referral of the complaint. However, there is no penalty for failure to comply.
This is an IDR. Failure to comply is.
Well, okay.
Failure to respond to my complaint.
Seriously, we haven't made referrals to the Ethics Commission in a few months. We will again at some point, I presume. I think we should have a way to document both substantive violations and substantive problems in the handling of a records request or a meeting issue, as well as procedural issues with how departments respond to the task force 21E, sending the wrong person, delaying, and that those are either aggravating or mitigating factors. And, at some point, I think that could lead to an issue of a willful violation.
But through the chair.
That's good language.
Right, through the chair, aren't we just, at the end of the day, repeating what's in the Sunshine Ordinance in our complaint procedure? I mean, all these things that we're saying are we're just saying, well, no, but these violations are really the violations. I mean, it kind of, I understand the point, but these things already exist in the Sunshine Ordinance.
But the ordinance doesn't really spell it out. And so the complaint procedures gives us an opportunity to say, here's what we want, here's the information we need to make a judgment, and if we think you're a bum and you're a consistent bum, then we're going to make that known. And if someone wants to enforce that, that's the idea here.
I'm done.
But that's what we actually do.
But I think there are these instances in the procedures where we can.
All right, why don't you spell it out and get it to Victor, and next month we'll see a clean copy of this, okay?
Yes. All right.
I want to move the agenda along, so...
this matter will be, I think, if someone would like to make a motion to continue this matter to the
April 1st.
To the next meeting of the task force.
So moved.
Second.
There's no members of the public to comment without objection. Okay.
Where's everyone?
Ms. DCA Kohler would like to comment.
Next on the agenda, item number 20, file number 14073, proposed amendments to Sunshine Ordinance Section 67.29-5, calendar of certain officials. I believe that Supervisor Avalos has submitted a similar or the exact same ordinance at the Board of Supervisors for review and approval. And I believe the committee did come up with several suggested changes to this ordinance.
So we did indeed. We talked about them last time. And how are we going to proceed to make sure that our language is in the proposed amendment? Remember, Hepner, were you going to do something with that?
Yeah, and I have yet to hear. I don't know the status of this of the legislation that Supervisor Avalos put out. You know the status of it.
Member Pelfel, what do you know about it?
So this was introduced at the board February 10th. It was put under the 30-day rule, assigned to the Rules Committee, and so action can't be taken until March 10th, which is next week. The language, I think, is exactly the language that we had.
It is the exact language.
Yeah. It's file number 150156. Aside from the content and what we talked about last month about whether it can be amended, blah, 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 I think the practical issue is whether there are going to be 6 votes at the board. And if there aren't, then, and if no one's working to try to make that happen, whether here or elsewhere, then this is just a fool's errand. And we should probably talk about that. We can lobby, we can't lobby. We should figure out if there's a way that this is actually going to become law and not just be a great idea that we thought of and the grand jury thinks is great and blah, blah, blah.
So should we go to the rules and...
Well, I don't know when they're going to schedule it. Supervisor Avalos chairs the Rules Committee now, but we should talk about drafting a letter that says why this is a great idea and why it's not going to burden them so heavily and why department heads will benefit by having clarity in the language, et cetera. Either we're in favor of this and trying to make it happen, or we're just sitting on...
No, we are. This
right,
is what...
Through the chair, shouldn't Supervisor Avalos be doing this since he presented it?
Or we could invite him to come here or ledge aid and talk about why they think it's a great idea.
I'm just trying to understand the mechanics of what we can do and what's within our purview.
Well, if you recall this, the civil grand jury made this recommendation. We said that we agreed with it. Richard Nee brought us a document where he made some recommendations along these lines. He was here when we heard this last time and suggested a way to ensure that everybody who the spirit of the law wanted to provide these calendars did. So I think this is in line with what we have agreed to do. So this is kind of what do we do now to make sure it happens. Member David.
So I would recommend that we put this on our agenda for our next month's meeting agenda as an action item that we are going to vote to. I'm sorry, it's getting late, and I apologize. The words are coming a little slower to my head. That we support the Avalos legislation in basically in concept and it's substantively, and that we would encourage along with we agree with the civil grand jury that we would encourage the Board of Supervisors write a letter to each member of the Board of Supervisors as the task force saying that we support this legislation in concept.
Well, why can't we? Why can't we vote on it now? Yeah, I don't think we need to. No, we've heard this. We agreed. We sent the letter to the judge, so we're behind it. So
then I make a motion. I would like to make a motion that we. I'd like to make a motion that we send a letter to the Board of Supervisors that the Sunshine Ordinance Task Force endorses that John Avalos' legislation in substantively, and that we encourage its adoption or approval.
What about appearing at rules too?
Before we move on from that, I believe there were several recommendations from the committee regarding possible amendments or additions to this regarding the title, limitations on disclosure in regards to unwarranted invasions of personal privacy, virtual meetings should be included in calendar requirements, statement of affected parties should include elected officials and department heads.
Are those changes reflected in the version we see here online?
No, it is not. This is...
what are you pulling from? Sorry.
This is from the committee meeting.
You mean the Rules Committee, just to be clear?
I believe it was the Compliance and Amendments Committee.
The Sunshine Ordinance Task Force's Compliance and Amendments. Thank you. I'm sorry. That's where I was trying to... Gotcha.
There was a discussion and there was a possible recommendation that certain clarifications needed to be made to the legislation. So I don't know if you wanted to send those recommendations to Supervisor Avalos in this letter.
But we're not seeing those changes as a committee.
Oh, right.
They were conceptual. I don't have specifics.
It's on our notes, administrator's notes for tonight's meeting.
Gotcha. Okay.
So, Member Hepner was going to work on this.
Could I?
And it's, no, just, hold on.
I'm feeling a lot less adamant about the concerns I had at this time than I did at the compliance and amendments hearing. That said, very, very briefly, the idea is to indicate that the title of this section should be changed to calendars of elected officials and department heads, as opposed to just calendars of certain officials.
It should be elected officials and department heads, right?
That the affected parties should include all elected officials and every department head, as opposed to just the enumerated individuals.
Were you suggesting that there are others that aren't covered?
Yes, there are other elected officials that are not listed here that should be covered.
Such as? Help me.
I mean, there are a lot of elected officials that aren't.
These are the only citywide elected officials that aren't judges.
What about school board members?
We don't have jurisdiction over the SFUSD.
Okay, wonderful. Well, then we can.
Much to my chagrin.
I think the point that Rick Nee was making was we wanted to have this be inclusive of any conceivable elected official. You know, if we want this to be sure to cover everyone.
No loopholes.
Yeah. Elected officials and department heads.
Isn't that exactly what it says?
That's what we mean. Not certain officials, as it reads now. Calendar for certain officials. We have a problem with that. We want it to be for everybody, elected officials and department heads.
Right. Additionally, we want to make sure that this applies to in-person meetings or other meetings, in-person or otherwise. So where it says the time and place of each meeting, comma, in-person or otherwise, or event attended by that official. And that is to account for, say, virtual meetings.
Okay.
Could you let him continue, please? Member Hepner.
And then there were concerns expressed about the exception for calendar items that would constitute an unwarranted invasion of personal privacy, and that's sort of dependent on other bodies of law that we don't necessarily have access, that we're not really considering right at this moment. I think that's kind of a lesser consideration, and that will play out as it plays out.
So basically, the changes we would like to recommend is changing the title so that it's clear that elected officials and department heads, all of them are included, and including virtual meetings. The other
Those are two main
business about the personal privacy is there's not a whole lot more we can do to change that language or clarify that. Is that what you're saying?
Right.
Okay. So
perhaps we can take a motion to move on with those changes.
So wait, it is late, and I've had such a long day. So what do we have on the floor right
now? I believe the motion is to send a letter to the members of the Board of Supervisors expressing support of the proposed legislation. And in addition to that, provide suggestions of possible changes, including those that we have just stated.
Mm-hmm.
And I would like to confirm what recommendations you would actually like me to send, or like the chair to send.
Yeah, the statement. Okay, so just to reiterate what Member Hepner said, statement of affected parties should include all elected officials and department heads, and the title of that particular section of the ordinance should be changed from calendar for certain officials to calendar of elected officials and department heads. So basically, we want to cover everybody. So the title needs to be changed, that initial sentence needs to be changed, and then virtual meetings should also be included. And then we're going to let the vagueness about the personal privacy and all, we're going to let that go. We don't have any good ideas about that. And so...
So just to clarify, Chair, that's line 20 for Victor. Place of each meeting or event attended by that official, virtual or otherwise. Is that language you want, Member Hepner? Line 20?
Yes.
Okay.
I mean, if, to the extent that makes sense, it's just a recommendation to make to the Rules Committee to indicate that we want this to be inclusive of like conference calls and sort of Skype meetings to the extent that things are happening more digitally.
Right. Member Pilpil.
So I heard a motion from Member David. I didn't hear a second.
Second.
I think I was with the support in concept. Now that we're talking about these specifics, I'm more troubled by this. I'm tending to think that we should have a draft letter before us that spells this out. I'm getting really nervous about like the virtual meetings and things. I had a conversation with John Givner about the process that he used to craft this language and not to take Rick Nee's language exactly. And there were specific reasons for that. I don't think John's going to come here and talk about it, but we could invite Supervisor Avalos' aide to talk about that. And I think if we put out a communication to the board saying, we like it and we suggest these, or we only like it with these things, I think that could possibly tip whether the thing passes or not. I mean, I think this is really a close measure, and if we do this wrong, it's going to fail, and that might be bad. So I want to think really carefully about this for those reasons.
Through the Chair, if we do nothing and just say we're behind it, that might be the best thing we can do to get it through. I think if we start nitpicking, although I agree with the details, we have to consider.
And I'm not disagreeing with the details either. But.
No, it's really putting on different hats. Are we, advocating for an idealistic version of this, or are we trying to support something that's going to get passed? And I understand the difference between the two. So if we are going for the far ideal, then there are a lot of recommendations we can make if we want to make sure that that our support is behind something that is at the very least an improvement over what we've got. Then I'm okay with sending a letter saying we support the existing language.
Could we first send a letter to Supervisor Avalos with saying we support your proposed amendment? We have these suggestions. Invite his staff person to our next meeting, and then
consider further
see, and then consider further action, and then we might end up then sending a letter to the full board supporting whatever. How does that sound? Do we have time to do all those things?
I don't know that we have time to do all of it.
That's what I was going to say. I don't know if the whole timetable and the grand jury and all that we're up against that issue as well.
Member Wolf?
And the
Yeah.
30-day issue that
I mean, it's a little bit strange to do so, but I think that we could either have a member of the task force reach out to Avalos with the items, or we could send the letter as the task force with those items, and then we can do a separate letter at the same time right now saying that we support Avalos' proposal. And although there is this kind of mixed messaging going on, I don't think it's going to matter.
That way, Avalos has the support, if he needs to get his votes.
Yeah.
Yet, he also has the option of doing some last-minute changes that look like they came from him, if he chooses to do that.
I like that. Okay. I like the two-pronged approach. So, yeah, we try to get it the best version we can. Barring that, we support what he's put forth. That makes sense.
Could I suggest
Member
as a
Pilpel?
slight alternate that we authorize a letter, which gives you the discretion to send or not send, a letter in general support of the thing, and that we communicate, perhaps through one of our members, to Supervisor Avalos and see if they're intending to move it this month. If they are, and the letter would help, then we send the letter. If not, then we draft a broader or different letter, if necessary, and invite them to speak at our next meeting, so that we could move if it's useful, and if a more nuanced strategy is useful, do that instead. But to authorize at least a general letter of support at this point. Does that?
Okay, let me see if I
there's some
understand
strategy
you.
to this, is the
Okay,
point.
all right. So the first thing we would do would be to send a letter of support for Avalos amendment to the Board of Supervisors. And then the second thing to do is to see where he is and let him know that we have some other ideas. So, Member Hepner,
Yes.
can you tackle that?
Yes,
and
absolutely.
be in contact with me about, yeah. And I think, so our motion,
vote on that.
yeah, I think the motion that we have covers, okay, all right.
Just to be sure that I have this correctly, I will go ahead and draft a letter of general support regarding Supervisor Avalos' legislation. I believe that the chair is authorized to sign and send that as needed. I believe that you are requesting that Member Hepner contact Supervisor Avalos' office in regards to possible improvements to the legislation.
Right.
And scheduling of.
And also run a letter to the Board of Supervisors, run that by Member Hepner as well.
Yes.
Okay.
And if the motion is restated to say authorize rather than send, I feel a lot better.
Okay.
You were the main.
There are no members of the public present. Is there any?
I'm sorry, I feel like, what was that, Mr.
I was
Member
just
Capel?
suggesting that if the motion is to authorize a letter rather than direct that it happen.
Fine,
Okay.
yeah.
Great,
yes.
I appreciate that.
Is there any objection to that motion? There being no objection, that the motion is passed without objection. Next on the agenda, item number 21, file number 14065, update and proposed response, civil grand jury report, ethics in the city, promise, practices, and pretenses.
All right. I just have some suggestions to now update in a couple of places because some time has passed and we've done some things. So, for example, on the second page, it's about 2/3 down. Task Force's follow-up response to the recommendation about reviewing the websites. The last sentence in the Task Force's follow-up response, the Task Force is preparing to send a memorandum. We can now say we have prepared a memorandum. We're now in a, we're now just not saying we're going to do things, we've actually are doing things. The following page, the task force has prepared a memorandum to department heads reminding them of the department head calendar requirement. We have drafts of those. So I'll just hand this over to you with my edits. So members, anybody else have?
Through the chair, did the presiding judge change? I missed that.
Yes.
Okay, thank you.
So if I could just,
Member Pilpel?
for a moment, I was not at the August meeting where we approved the responses, but that's fine. You guys did great work on that. What I did following our discussion, I think at EOT in January, is that when we did this? Yeah. Was draft what you see here as Task Force's follow-up response. I had a version of this that had just those 5 things in boxes, so it was easier to find, but I guess that didn't print. Anyway, so the recommendation and the Task Force's prior response are old language. That was from the report and from our prior response, just cut and pasted verbatim. The follow-up response was the new language that I crafted based on our discussion.
I think that's very clear. It reads, I read the whole thing.
Okay.
It reads, it's clear.
Okay. And I was just trying to reference what we're doing,
Right.
and so that we're making clear. And I think then this is the end of the response to the grand jury. We still have things that we want to do, but there's that. And so that's how I drafted it. And I'm fine. Those changes are great. So.
And it'll go out over my signature, but I indicated last time, I think whoever has written the document or done most of the work should be acknowledged. So if you would also include Member Pilpel.
You would like 2 signature lines on the...
Yes,
thank
please. Thank you. I mean, I think that's, I want to do that. There's some, yeah.
Without objection.
I believe the motion is to amend and adopt the response to the final response to the civil grand jury report and send a letter upon final edits.
Yes.
Is there a motion to that effect?
So moved.
Second.
No members of the public are present. Without objection.
Next on the agenda, item number 22, proposed memorandum to department heads, department head calendars, and source of outside funding disclosure requirements.
Okay, once again.
Member Pilpel.
So this was pretty straightforward. The sentence where it says the full report is available at blank, we could probably just drop that. If anyone really wants to find it, they can call us and whatever. All I was trying to do here was to reference those 2 provisions, include the text, encourage them to do it, and just sort of, that's it, remind them to do it.
So, and the report that we just...
Said that we had prepared this and blah, blah, blah.
So we have, okay.
It's not the best work ever, but hey, I still think the more we can bug departments on a regular basis about stuff, whether it's existing law or proposed changes or policies, whatever, we should be poking them. So, that's great.
I just had an idea. It would be nice if we had some interns from like SF State and their poli-sci department to do things like look at the calendars and do tasks that require some research, gather data for us. Because I just took a quick look at the mayor's calendar a couple of times, and it's so bare bones, you don't know what he's doing most of the time. You know where he goes publicly, but you don't know about all of his other many meetings. They're just not there.
It's not an accident.
But it's in violation of the ordinance, actually. I mean, he doesn't, we don't know who he was meeting with at 10 o'clock this morning.
Can we as
in
a
his
task
office.
force file complaints against people as a task force member, or do we have to like... Okay.
Yeah, we
and
can.
people have.
So, if you want a little project like that, Member Wolf.
Not taking on the mayor right now.
You and Mark Lenhope telling you.
All right, so
Is there a motion to approve the letter?
I would so move. And I do think we should just
A
pull that
second?
line out.
A second. Okay. There's no member of the public here to comment without objection. Okay.
The motion is passed without objection.
Thank you.
Item number 23,
Perhaps
request
I'll
for
bring more
proponents
stuff
of
next
complaint hearings until further notice by anonymous.
All right.
I believe that Anonymous has recently sent me another email. This is the second time that she has done this in the past few years, asking that I postpone all her complaints until further notice.
Is there a shelf life on these eventually? Do complaints eventually expire, or will they just carry
There's-
on and our progeny will be hearing them 20 years from now?
There's nothing written regarding statute of limitations.
That's the words I was looking for. Okay.
Could I?
So the options,
I believe that at the last Compliance and Amendments Committee, they made the decision to table the matter without prejudice, which would allow the complainant to refile the complaint at a future date if she so desired. I believe I listed several options. Item 1 is to approve the postponement until further notice as requested. Option 2, approve postponement for a specific number of days, maybe 30 days or 60 days, but I don't think that would be of much use. Item number 3, I would continue to schedule the matters with a very low priority according to established procedures. And if she does not show up at the scheduled meetings, we would table the matters without prejudice and allow for refiling at a future date.
and Victor is recommending that latter, which is what we did at compliance and amendments. She didn't appear. We thought we're going to treat this as we would any other complainant, and we've treated her, given her many special accommodations, and so the recommendation from Victor and from me would be to continue to schedule them, notice her, give her an opportunity to appear, and if she doesn't, then we table the matter, just as we've done for other complainants.
Through the chair.
And then she would be noticed that that's what's happened, and she can refile at a future date. Member David?
Yeah, I just want to be clear. So if that were the case, we would be voting to not grant her a postponement. Is that because on the agenda it says request for postponement? So would we be
right? We wouldn't. No, we would not grant her this postponement, keeping these on our books for many more years, because they've been on the books for years.
Yes, I just want to make sure I understand. Yeah.
Member Wolf.
So we're not granting her a postponement, and then we're going to keep scheduling things that we know she's not going to go to?
Well,
I don't like the idea of that. It feels kind of self-sabotage. Slippery, yeah. I think that granting her the postponement to X number of points that we want to, and then notifying her that she has until X point to file, or else they will be extinguished or something like that to, I don't know whether we can even work that through our process itself, but it feels weird to deny someone a postponement, schedule their hearings when you know they're not going to be there. What are we going to tell the respondent?
Yeah, I see your reasoning. Member Pilpel.
Just thinking out loud, I was almost ready to just file or table the 2012 and 2013 things, because it's like, from my perspective, that stuff is really getting old. I might be willing to grant a 60-day continuance for all of these, and then we schedule, and if she doesn't show up, however we handle that, then they can get tabled with the option, the usual option to refile. I mean, I don't think we just open files and keep them kicking around. This has got to get dealt with. And I'm sorry about the hell and the what, but this, how is this helping anybody?
Member David?
So my memory is already getting fuzzy, but didn't we earlier this evening basically grant Victor the authority to?
That would be on first request. None of these are. That would be on the first time continuance request.
Okay, so I have a question. Do we have an option tonight to table? So if at the end of the day, what we're saying is pragmatically would happen is that if we were to not grant the request and that we were going to schedule these, we don't think she's going to show up, and then they're going to get tabled, and then they go away. Can we tonight cut through all that and table these tonight? Can we make a motion to table these? Or does that have to be on the agenda?
It would need to be scheduled, calendared, and she would need to be notified that we plan to table the items.
So I would like to, I would like just to have a conversation. Maybe I'll start with making a motion that for next month's agenda, we have an item to table all of these items, and that she's notified, she has an opportunity to come for the discussion of tabling her items. We don't need
or sending something in advance to explain why we shouldn't, or whatever.
Right. My point is that the respondents don't have to show up for that conversation, right? It is pretty much laying out to her, this is the game, this is what we are thinking about doing in a very direct and not kind of end around way. Member Wolf, how do you?
I'd like to.
I think that makes a ton of sense.
Okay, is that a second?
Yes, I second that.
Okay, so, all right. To me, that sounds almost equivalent in a way to postponing these. So what we're doing is saying we're not going to hear them anytime in the near future unless you let us know that you want us you want to refile and want us to hear them. And
No,
you're-
I mean, I think we're actually having a hearing to dismiss all of her all of her cases, essentially. And if she decides to respond to that hearing or not show up to that hearing, then we'll just dismiss them without her response. But basically, we're setting up the opportunity to dismiss these in one fell swoop and avoid that issue of scheduling things and having respondents go there when we know she's not going to be there.
Yeah. Okay, but she would still, we can table them, but she could still refile, and she'll be notified that she can refile.
I mean, anyone can refile anytime they want to. That's
Absolutely, yeah.
I guess I would, again, feel a little more comfortable if it was just the 2012 and 2013 ones. I guess I'm not yet ready to totally kick out the 1, 2, 3, 4, 5 that are more recent. I mean, at some point, I'll be ready to. It's just that there are others from around that time frame that we haven't heard yet.
She does have a few 2015 complaints that this probably should not apply to.
Yeah.
As they are new and they've never been postponed in the past.
So through the chair, I'm open to, suggestions or friendly amendments as to until what day, having on next month's agenda all complaints up to a certain date.
Okay.
By this, by anonymous.
Okay, so what makes sense? Member Rummold?
How about all that have already been postponed once?
Some of them haven't ever been heard. That's
They're
the
just
problem.
really-
I know, they've been postponed.
They've been scheduled, though.
They've been scheduled and
No,
pushed
some of them have just never gone to a hearing. They've just been in limbo for that entire time.
Well, then let's not get rid of those.
Well, wait,
And
because,
we'll postpone them, and then we can do the same thing again.
well, the really old ones, so what about the ones in
I believe
2012?
I believe 2012 and maybe 2013, we can go with the method of stating we're going to have a hearing to consider tabling all the matters.
Because the reason they haven't been scheduled is because she didn't want them to be scheduled. So it's sort of postponing. I mean, right?
She can always refile on those complaints.
Right, but I'm just wondering the history of those really old ones?
They've all been postponed at least once.
Okay, all right.
So, Member David, if you would do just 2012 and 2013, that's 20 out of 25. That's most.
So I just want to make sure. I think I just heard Victor say that all of those of 2012 and 2013 have been postponed at least once.
Yes.
Okay, so I actually would prefer to go with the language of all cases that have been postponed at least once. So then it can be, if we want to put an end date on that, that's fine. But I kind of like procedurally that it has been given.
It accomplishes the same.
Yeah, that's I don't know how. Go ahead. Yeah.
Member Wolf.
I mean, I understand the argument around only things that have been delayed once, but what she's asking us to do is postpone everything until further notice, and really the closest syndicate to that we can do is to knock them off, and she can reapply them when she wants. And I mean, I think this is the closest thing within the clean operation of our task force that we can do to what she's asking for. She's asking for everything to be put on hold, and essentially dismissing everything is putting it on hold because you can always reapply.
Right, okay. So do you want to, Member David, you want to revise the language of your motion?
No, I kind of want to be a little bit Solomonistic about this. I do think that the more recent, the 2015, so I do like I personally, and I like any of the complaints that have been postponed at least once to be brought up to be agendized for a conversation or a motion for them to be tabled at next month's hearing. Is that clear?
Yeah.
And so that's the way I would. That's my personal. And then if time goes on and there's 5 out of 25 are remaining, we can then deal with those 5 at a later time and maybe do the same thing 6 months down the road. But I think this is this is a way to deal with an overwhelming majority of these cases. It seems in a fair-minded way to me.
And so the second accepts whoever that was.
Member Wolf.
Member Wolf? Yeah.
Do I have a choice here?
Yeah,
Yes.
I'll retract my second and someone else can second.
I'll second.
Okay. All right. There's no member of the public to comment without objection.
Just to clarify the motion, there were several versions. The motion is to schedule a hearing at the next meeting of the task force to consider tabling all items that were filed by anonymous that have been previously postponed. Yes, thank you.
Well, let's be clear. It's not a hearing on the substance, so it's
No. It's a discussion.
to schedule an item to consider tabling those items filed by anonymous that have previously been scheduled or continued at least once.
Yes.
And should we also agree to continue the ones that have not been continued once?
No, I think what we're saying is we're leaving them aside for the moment.
Isn't that what she's asking for here?
We're just going to put those.
That's a good point.
Oh, yeah. As usual, Member Rummel makes a very good point.
Thank you.
Okay.
As does everybody on this body from time to time.
So maybe if we recalendar this for not a request for postponement, but for consideration of action or disposition on all of these files, and we could decide next month that these we're going to table and these other ones we're going to postpone for some short period of time, so they're still in the queue, and then at some point soon. I mean, we're getting close to the end of all this mess.
So if the member Pipel will allow me, I'd like to restate the motion, and it's going to have two parts to it. The first one is going to be as stated, that to table to have an action item to table motions that by anonymous that have been postponed once. The second will be to have a vote to continue items that have not been postponed once yet. Does that handle? So that should handle every one of these files numbers 12031 through 15007. Every one of those should be either is going to be tabled or is going to be postponed, or there will be a discussion about those two things at next month's meeting. The differentiation is, has it been postponed yet? Has one of the files been postponed yet or not? Is that clear? Or am I being...
I will draft something and submit it to you for review before I place it onto the agenda.
You understand? Yep.
We should come to the meeting next month. It'll be fun.
All right. So.
Does that make?
Yes, that does.
Yeah,
That
it does. So.
I believe the motion is to schedule these matters listed at the next meeting with motions to either table or continue the matters based on their status. And I will submit a copy to Member David for his review prior to placing it on the agenda.
All right.
And I renew my second.
And no members of the public are here to comment, so without objection.
There being no public comment, is there any objection to the motion? The motion passes without objection. Next on the agenda is item number 24, Administrator's Report. I just wanted to go through it quickly. The hearing schedules for the upcoming month, March 9th, EOTC at 4 p.m. The March 17, 2015 Rules Committee meeting is canceled. However, the Rules Committee will be acting as the Complaint Committee on March 17th.
So members Hinsey and member Rummel, you're here. You're not off the hook. You have to be here. And if you can't be here, make sure you tell Victor so we know.
And the next meeting of the Sunshine Ordinance Task Force is on April 1st. Communications. I did email everyone a copy of the Statement of Incompatible Activity. That's an annual requirement that I submit a copy to the members every year.
Victor, if we have questions about that, about something specific, are we supposed to, I mean, they always say, call our office, but nobody ever says, which office? Do we call the city attorney? Do we call the clerk? Do we call
Clerk of the Board's
ethics?
office.
So we just call Angela Kilvillo's office and whoever picks up?
Christine, I can give you the direct contact, but anybody from our office should be able directly to the
Okay.
correct person.
I think Christine.
Yes, I just don't know how to pronounce her last name correctly.
Okay, so there is somebody, because when we went through Sunshine Training last year, which was, God, where was that, Allison? We were in that theater,
I
and that
think
guy
it was February of last year.
That guy was sleeping in front of us. Was it the North Theater or something? They kept saying, call our office, but they never said what office it was or who to call. And
Ghostbusters?
There was some information from the controller about the whistleblower program. There are two private companies who sent us letters regarding programs for public record searches. If you're interested, their flyers were attached to the report.
That's not actually open pubic records. That's never mind.
that happens a lot, that error.
We don't know what business they're actually in.
The Community Housing Partnership regarding file 13030 and 13039, they have complied with requests to have their 2 annual meetings per calendar year. A copy of their compliance letter is attached.
I will read that carefully. I ran into Charles on Muni the other night. So,
a reminder, I did send out a reminder that the Ethics Form 700, Ethics Training Verification, and Sunshine Training Verification is due to be submitted to the Ethics Commission directly by April 1st, 2015.
Is there going to be another class, or we have to just do that on our own?
I believe that was the ethics version, and I believe you only need to do that every other year.
So then what is the ethics training verification and sunshine training?
It's just like a video you watch.
But do we have to
If
do
you
that
already
again, or
done
to
it-
count what we did last year, is my question.
I believe that one is every 2 years, and if you've already done it, you don't need to do it again. But I will verify that they have your form from last year on file.
the ethics is every 2 years. The Sunshine Declaration is every year.
But the sunshine declaration is just a declaration, or do we have to watch that silly
Yeah,
video?
it's just the declaration that says you've
We
actually
just say-
read the ordinance.
We say, I'm kosher, I'll do it, yep, okay. But the newbies will have to watch that 2-hour video, right? If they weren't here.
Yes, I believe they've already done it when they were
when they were
appointed.
Oh, okay.
Several complaints submitted. I have listed them here. And then you have my log of existing complaints, a total of 54, with approximately 30 by anonymous.
So those are all just going to go away then?
We'll find out next month.
Couple of questions.
Yes.
Item 5 says the time period is January 1 to January 30th. Is that actually February?
I believe so, yes.
Okay. And the one thing that I'm not, I guess I'm seeing it on 15013. If there's a way to sort of indicate which things are most likely to pop up for the next meeting, then we could start to sort of think about that. I mean, I guess that's, the 15013 is the thing that we talked about earlier, the BARF thing. But do we know, for example, what complaints are likely percolating for next month?
I don't predict it that far out.
Okay, so that's why.
That's a little bit of an art form for me to decide who to put on what agenda.
That's what makes it interesting. That's why we should read the agenda.
I try to bring in all the complainants I try to match them up so I don't have to bring in as many people for each meeting. Like today, I brought in Piccarello in earlier than I usually would so that I can hear both fire department items at the same time.
I mean, ideally, something like Piccarello from mid-January would be here around this time, and we'd be all caught. I mean, that was good. That's like firing and.
We're getting there. We are.
That was very.
Due to our creativity and Victor's creativity and our flexibility and goodwill.
And patience.
Also, 2 issues that I wanted to bring up. There was discussion regarding the budget of the task force. I don't know what you wanted to do with that. The other thing was there was discussion from many departments regarding abuse of the Sunshine Ordinance and the California Public Records Act by certain people. There are certain people in the city I receive 10 to 20 emails a day from to very specific departments, and they ask for sunshine documents. However, I think it's becoming abusive in a way.
So these are members of the public who?
One member of the public sending 20 requests to the same department in a day, and I've had requests from departments to possibly address this issue, but I don't know if there's any solution to that.
And it's not Paula, it's others.
Member Wolf.
This gets really dicey really quickly.
Yes,
that's all I'm going to say.
You'll probably hear from the departments at our next meeting regarding this.
Okay. The budget thing, though. I think we should, the city's flush with money right now. I don't see why we can't lobby to get our meetings videotaped. I mean, we're going to have to up our game a little bit so we look nice, but...
Some of us might have to cut our hair.
To do anything.
I wasn't referring to you.
You look great. I mean, we can all...
I'm a little behind my haircuts.
Cola looks sharp. He's got a tie on.
Yeah.
That's why he's up front.
But, it's something we could ask for. And we also need more time from our DCA COLA here.
Please, no, please.
So on that,
So, yeah,
could I
Member
suggest
Pilpel.
Could I suggest that either in the administrator's report next month, we have the budget presentation that must have been made at Budget and Finance from the clerk's office with, in particular, the slide about the task force and its funding, and that we consider a letter and that you draft a proposed letter with whatever we want to ask for. And we can discuss it then. I don't care what's in it right now, but if we want to say, Nick's Hours, TV, whatever, let's talk about it.
Yeah, no, this should be on the agenda for next time.
As an
The
action
budget.
item.
And I think we should ask for a lot. We'll get less, but let's go for it. Huh? Absolutely, yeah. Member Wolf.
On a related note to the live videotaping thing, it's pretty simple to set that up on our own. And the question is, what would be involved with actually getting that onto the city's website?
That's interesting.
Because the ability to set up a live stream through YouTube, I have the equipment. I could set it up. I can't film the camera, obviously, while talking, but we have the means to do it. I had talked to Victor about setting it up for this month, but the person I'm working with actually went on a road trip, so it just wasn't feasible. But all the technical wherewithal is quite simple. It's just a matter of whether we can nexus it to the website, et cetera, et cetera.
Well, I think that's the issue right there, is they'd have to create a back end and a front end and a whole database. And I mean it's a project.
They really only need to put one line of code on our page to do it, but getting them to actually do that is a project.
Well, no, it's
embedded.
more than,
no, it's an embedded.
but it's storage. It has to go on a storage area network.
No, it's not. It's an embedded iframe. It's streaming through YouTube. It doesn't really.
They can't. The rules. They can't stream through YouTube. It's absolutely forbidden. I know people need to. That's absolutely forbidden. It's considered like a security
Craft a
breach.
sentence or two,
outside.
put it in the letter, and we'll talk about it next month, right?
It's policy. You
Yes,
can't.
people
It's off.
go on.
Are
you trying to move?
There's a
It's on.
Well, yeah,
it will
I
be
mean-
placed on the agenda for discussion next month.
Honey,
Okay, so it'll be on the agenda next time, our budget and ideas for how to
a project like this for the DA's office.
Fundraise, bake sales.
make
I also, wanted
us more visible.
I also wanted to suggest that one of the committees take up discussion of drafting a guide to departments regarding policies for complying with records requests. Various departments have asked me for a guide on how they should be preparing and responding to these requests. And in addition to that, we have requested this information from various departments.
Can we talk about this Monday at EOT?
Yeah, I agree. I think we need just a basic template that we say here.
Would you like me to place this on the Monday's EOTC meeting?
Yeah, that seems like the best committee for it.
Towards the end, yeah.
Yes, thank you.
I mean, I'll write something. I'm just not doing it tonight, so.
No.
you know.
I would need it by Friday morning.
Yeah, it'd be nice to give them something electronically. Better yet, have it.
I just need to have the
with
subject
you.
matter on the agenda.
Yeah. Let's talk about it Monday, and we'll figure out what to do.
Okay,
That completes my administrator's report. Next on the agenda is item 25, announcements, comments, questions, and future agenda items.
Member David?
I just have one question. I'm just wondering, has there been any communication with the Rules Committee, or have there been about, excessive absences of a couple of members on the task force? I mean, I of all people understand that life gets.
Sitting right here. Talk about it.
I believe that letter was drafted. I'm waiting final approval by the chair.
The one from like 2 months ago?
Should we put that on the agenda for?
That was already reviewed by the task force. I'm just awaiting final. I made some amendments to it based on comments.
Which chair? Me chair or
Okay.
Chair of the task force.
So would you nag me about that?
Yes.
Feel free to nag me about things.
Okay. I mean, if we want to
Member Pilpel?
if we want to go further on that, there was a draft letter that named some of us. I think under the bylaws, whenever we trip that 3 in a year thing, another letter needs to get sent, whoever is the person here. Right. And I don't think that should really be a discretionary item. Let the chips fall where they will. And
Member Wolf?
That all sounds, but how does that work for absence 4, 5, 6? Does that trigger a new letter? Is it every 3 absences?
We haven't gone to that extent yet, but my understanding is every additional absence would trigger another letter beyond 3.
Is this an item that was on our bylaws review?
I believe it, not on this go-around, but it is in the bylaws.
Yeah, it was tightened up the last time the bylaws were reviewed.
Should it go back for discussion? I mean, I get it
To
being
be strengthened, do you mean?
well. I understand that it's useful as a tool for the chair to encourage attendance. But if we're not careful, it's also, we put it in the hands of the Board of Supervisors where they say, okay, this one's gone. You're now at 8 people. Oh, now you're at 6. Well, now you can't meet anymore. So it's a double-edged sword, this, and that's what I'm just drawing attention to.
I would say there are potential problems. I think we've now loaded up next month's agenda with lots of stuff. Maybe we could talk about it in May. And I'd also note that the board, neither the full board nor the Rules Committee can simply remove a member on their own. They'd have to hold a hearing. There's a process. It's not easy to remove someone from office. It's really even stronger for us because we're officers and not just members of some low-level skateboard some other advisory body in the city. Yeah. So,
skateboarder.
I mean, I get the point, but let's wait a month and see.
No, it's fine.
We
I
can
just
discuss this
fair.
along with the bylaw amendments at the next
Literally a
meeting.
question.
What's that?
We can discuss this along with the bylaw amendments at
I
the
think
next
that'd be a
meeting.
good idea because I sense the spirit of it, but we have to be careful to not.
Unintended consequences.
We just want people to show up. I mean.
Yeah. So is there anything else before we call for an adjournment?
Yeah, I had a couple of things. So when I wasn't depressed last week, I went out and saw the movie Citizen 4. I would encourage people to see that. I thought it wasn't actually the best made film, but obviously the topic's important. I think just as we talked earlier tonight about being more proactive in a variety of ways, I think we should think about privacy and its dimensions and ways that we both protect citizens' privacy and at the same time make participation in government happen. And that's tricky, but I mean, that movie just kind of scared me. And
The movie was excellent. I saw it when it first came out.
Rick mentioned last month about the SPJ Awards. Do any of our, Allie's not here, Josh or Mark, do you know about the awards next week?
I know about it.
On Thursday.
Anybody we know getting one, or we don't know yet?
The executive director of. No.
Okay, got it. Okay. At some point, not next month, because again, we're busy, I found out that the city has an Office of Civic Engagement and Immigrant Affairs that largely staffs the Immigrant Rights Commission and does other things. Because civic engagement is in their title, I'm kind of interested in what they do to that end, and I'd kind of like us to invite them to make a presentation at some point, either to the full task force or a committee, and tell us what they think the civic engagement part of their office is and how that relates to what we do.
Be a future presentation.
Yeah, not a big thing. I'm not trying to, whatever. I'd like to know.
Pill, are you looking for a date?
That probably too. Maybe I wouldn't be as depressed. The Mark Farrell letter on the Board of Supervisors Finance Committee, we authorized that last month. Did that go yet? Not so much?
Still pending.
Okay. Can we maybe, because we talked about making them do a thing early in the budget process.
Right. I saw that letter. Could you nag me about that one?
Yes. Okay. And just finally, the Supervisor of Records annual report. I think we did the one last year that was covering calendar year 13. I don't think we've yet heard calendar year 14, and maybe we could schedule that sometime. Paula retired, so I think, what's her name? Julia Friedlander is now the Supervisor of Records. Whoever, if we could just schedule that at some point. That's an annual requirement. Yeah.
Just one last thought. If we're about to adjourn, we can all leave, but DCA Cole, you have to stay another 11 minutes.
Tables have turned.
Yes.
So is there a motion to adjourn?
Motion to adjourn.
Okay. Great meeting.
Yeah.
Great meeting.
Yeah.